The Honorable, the Chief Justice and Justices of the Supreme Court of Pennsylvania. Oyez, oyez, oyez. All manner of persons who stand bound by recognizance or who otherwise have business before this court may now appear and they shall be heard. God save the Commonwealth and this honorable court. Please be seated.
Good morning, everyone. Welcome to our third and final day of our spring oral argument session here in Pittsburgh, and the third day of absolutely different weather that we have every day in Pittsburgh. As you may know, the Pennsylvania Supreme Court is the oldest appellate court in North America. Our roots date back to William Penn's Provincial Court of 1684, and our Supreme Court was formally established pursuant to the Pennsylvania Judiciary Act of 1722. In 2022, we celebrated our court's historic 300th anniversary in Philadelphia, and we on this court are very proud of our court's rich history. It's truly an honor for us to sit in three magnificent courtrooms in Philadelphia, Harrisburg, and Pittsburgh. I'd like to mention a little bit about our Supreme Court history before we start the arguments. As you likely noticed when you were entering the courtroom, our court has a tradition of hanging oil portraits of former Chief Justices in our courtroom space. Yesterday, I spoke about Chief Justice James Drew, Chief Justice James Sterrett, and Chief Justice Robert Fraser. And I wanted to just mention the remaining Chief Justices on the wall, just as a point of interest. In 1961, by way of background, Governor David L. Lawrence appointed Pennsylvania's Attorney General Ann X. Alpern to become this court's first appointed female justice. However, in order to win a full term, she had to run for election, and she had to defeat Henry X. O'Brien, who she didn't defeat. Thus, he's the fourth justice pictured there. Alpern lost a very contentious election. During Justice Henry X. O'Brien's term as Chief Justice, he established our Lawyers' Client Security Fund to reimburse clients who were defrauded by their lawyers. O'Brien served as Chief Justice from 1980 to 1983. To his left on the wall is Chief Justice Samuel Roberts. After graduating from the University of Pennsylvania, Roberts entered a lengthy private practice in his hometown of Erie. He served in World War II in the United States Navy and was later elected to the Erie County bench and later to our court in 1962. He became Chief Justice of Pennsylvania in 1983 and served until 1984, after which, apparently he was a glutton for punishment, he became a senior judge on the Superior Court and a special master for the U.S. Supreme Court. To his left is a justice many of us knew, Chief Justice John Flaherty. After graduating from law school, he opened a solo practice in Mount Lebanon here in the Pittsburgh area, while at the same time teaching at Carnegie Mellon University. He was elected to the Allegheny County Common Pleas bench and gained notoriety for his controversial decisions, including closing an all-black middle school in Pittsburgh for illegal segregation and ordering the removal of fluoride from 26 communities' drinking water, an order that was later overturned on appeal. He was elected to this court in 1979, and he served as Chief Justice from 1996 until his retirement in 2001. Next to Flaherty is Chief Justice Steve Zappala, an outstanding athlete. Zappala played basketball for Notre Dame before moving back to Pittsburgh to play for Duquesne University. After serving in the Army, Zappala graduated from Georgetown Law School and returned to Pittsburgh to practice with his father and brother. He was elected to the Allegheny County bench in 1979, and 2 years later to the Pennsylvania Supreme Court. He served as Chief Justice from January 1st of 2002 to December 31st of 2002. While on the court, he initiated, developed, and fully integrated the largest computer automation system of any type in our country. Next to Zappala is Chief Justice Ralph Cappy, which is fitting because I believe they were always together. Cappy graduated from the University of Pittsburgh School of Law and entered private practice before beginning his public service in the Allegheny County Public Defender's Office. He became the director of that office before being appointed to the Common Pleas bench by Governor Shapp. He won a seat on our Supreme Court in 1989 and became Pennsylvania's Chief Justice in 2003, serving until his retirement in 2008. Chief Justice Cappy died unexpectedly in 2009, shortly before the opening of Pennsylvania's Judicial Center in Harrisburg. Because of Chief Justice Cappy's efforts in planning and developing and securing funding for that building, his portrait hangs in the Judicial Council room on the first floor of that building. Finally, our late colleague and my predecessor, Chief Justice Max Baer, he began his public service with the with the Pennsylvania Attorney General's office before moving to private practice and later to the Allegheny County Court of Common Pleas. During that time, he fought tirelessly to reform the juvenile justice system. After receiving national recognition for those efforts, he was elected to our Supreme Court in 2003 and spearheaded several initiatives to help speed up the appellate process for domestic cases involving children. He became Chief Justice in 2021 and served until his unexpected death in October of 2022. All of these Chief Justices from the Western Pennsylvania area are a part of our rich heritage of our Pennsylvania Supreme Court. Before we hear the first case, I would like to remind counsel of a few things. First of all, appellate counsel, please approach the podium when your case is called. I will then give a short summary of the case. You may then begin by stating your name and the party you represent, and please introduce your co-counsel to the court, if any. The justices are familiar with your cases, so I ask that you avoid any unnecessary recitation of facts or procedural history, and instead focus on the main issues on which we granted review. Counsel is welcome to rely on their briefs for particular issues. Please remember that we do not allow rebuttal. In cases where there are multiple parties represented by separate counsel, you should avoid repeating the same arguments as prior counsel. Please try not to interrupt the justices while we are asking you questions, although we may be interrupting you. A justice's question is not meant to trip you up. Rather, it indicates there are particular issues that we want to explore further. While there's no set time for argument in our court, I will advise counsel when the court is satisfied that all of its questions have been answered, and at that time, I will ask that you conclude your argument. Mr. Minner, please call the first case.
City of Pittsburgh versus the National Hockey League Players Association et al. Representing the city, Mr. Yazan Ashwari. Representing the NHLPA, Mr. Ryan McManus.
In this appeal by allowance, we must determine whether the City of Pittsburgh violated the Uniformity Clause by requiring professional athletes who reside in the city to pay a 1% earned income tax while requiring professional athletes who are not residents of the city to pay a 3% tax on any income derived from their usage of the city's publicly funded sporting facilities. The issue is a little more complicated and nuanced than that, but I trust you will enlighten us. Please proceed.
Thank you, and may it please the court. My name is Yaz Ashrawi, and with my colleague and co-counsel Jordan Blask, we're here on behalf of the appellant, the City of Pittsburgh. Your Honors, the purpose of the Pennsylvania Uniformity Clause is to ensure rough equality and rough uniformity in the assignment of the tax burden on subjects within a particular class. And the facility fee at issue in this case does just that. And it certainly does not clearly palpably, or plainly violate the uniformity clause. We're asking that you reverse the Commonwealth Court decision and uphold the tax, particularly in light of the presumption of validity that is afforded to this facility fee, the tremendous discretion that is afforded to local governments in matters of taxation, and the heavy burden that a challenger must overcome in order to strike a tax down. And as this court has said, any doubt about the constitutionality of a tax statute must be resolved in favor of upholding it. But there should be no doubt here. The facility fee at issue in this case does the exact opposite of create disparate or unequal treatment. It equalizes the earned income tax burden on a class of individuals.
And just to clarify, you're referring to it as a fee, but it is a tax.
Yes, Your Honor. The city has conceded it is a tax, and for that reason is treated as a tax, and there's no issue on that point, of course. It brings parity and equalization where parity and equalization did not exist prior. Now, regardless of an athlete or entertainer's residency, whether they live in Pittsburgh or Philadelphia or Columbus or Boston, they pay a 3% earned income tax on remuneration generated by performing at one of the city's publicly funded facilities.
And how does that relate to the taxes the non-city residents pay to their home municipalities?
Your Honor, because it is a tax, it can be used or considered for credit purposes just like any other tax can. And when you look at the language of the uniformity clause looks at tax uniformity within the territorial jurisdiction of the taxing entity, which would be the city of Pittsburgh. So, while there could be a plethora of other taxes that non-residents pay, whether those are non-residents that still reside in Pennsylvania or non-residents that reside elsewhere in the United States, there's going to be differences among those other taxes, no doubt. But the key here is, under the plain language of the uniformity clause, the burden on earned income tax at these publicly funded facilities is the same. It's 3%.
But, counsel, on the balancing, how can you aggregate a burden here that the non-residents would in no instance have been permitted to be assessed? I'm talking about the City of Pittsburgh school district tax. That could never be laid on the non-resident performers. So how can that come into the mix here?
Certainly, the reason it comes into the mix, Your Honor, is because it is a tax on the same subject. And when you look at the uniformity clause does not look at who the taxing entity is, and neither does this court. In Sharon v. Minnick, for example, the residents paid 10 mills on their income tax, while non-residents who worked in the city of Sharon also paid 10 mills on their income tax. Half of the millage, half of the revenue for the residents was allocated to the school district, a tax that non-residents are not subject to. And they raised the same challenge that has been raised here. And this court in Minnick looked at the overall tax burden on the same subject, earned income tax, determined that the overall tax burden was the exact same, and found no issue with respect to the uniformity clause.
But here in the city of Pittsburgh, they're two separate taxes, right? Not talking about the sports add-on, but just generally, the school district 2% tax is separate and apart from the 1% income tax. Is that correct?
It is the school income tax, the authority to levy that is separate. The tax itself is the same. It is an earned income tax. For example,
Right, they're
yes,
both earned income taxes.
Correct.
But they are separate.
there are separate entities that impose them. But that is exactly what happened in Minnick, and it also exactly what happened in the instructive Frey case out of the Maryland Supreme Court. In that instance, there was residents of Maryland paid a state income tax that non-residents that made money in Maryland also paid. Residents then paid a county income tax dependent on the county in which they reside. That the totally separate, imposed by the local county. The non-residents could never be subject to that tax. Instead, Maryland enacted a special non-resident tax, on its face applicable only to non-residents. And that special non-resident tax was equal to the local county tax that the residents paid. So there you have two different entities imposing same income tax under two different sets of authority, and then a special non-resident tax to equalize that burden. And Frey was...
I'm sorry to interrupt, counsel. Could I just go back to Minnick for a second?
Yes, Your Honor.
When I read that, it's a short case, but from what I gleaned there, it seemed like the tax, correct me if I'm wrong, in Sharon there, it was a 10 mil income tax on residents and non-residents alike. So isn't that right? So I mean, you have a difference, a distinction with a difference here, as opposed to what between that and what's going on here, don't you?
Not precisely, Your Honor. Minnick was very short, but if you read the ordinance at issue in Minnick, it did two things. Tax on residents of the city of Sharon, period, irrespective of where they worked. Separately, it imposed a tax on non-residents that worked in the city of Sharon. So facially, it distinguished on residency, right? So you could be a resident of Sharon and work elsewhere, that 10 mil tax still applied to you. But if you're a non-resident working in the city, that now applies to you. So slight difference. Regardless, if you look at the present case and you look at Minnick, you have two different taxing authorities. You're talking about an income tax on earned income, the same subject that is burdened by that tax. You're talking about non-residents paying a greater amount on the back end revenue-wise to the city in which they are not residents, exactly what's happening here. And you have a tax, as I just pointed out, that was not facially neutral, just like this one is not here. At the end of the day, the court, looking at the local enabling tax, which is still applicable today, it's been amended, but the pertinent language still remains, looks at the total tax burden aggregated for a single tax. And that is the earned income tax. And that's why the Commonwealth Court's reliance on Danny Luck is not correct. Danny Luck...
Before you get to Danny Luck, can I ask, go in a slightly different direction on the uniformity? What earned income tax does a non-resident pay in the city of Pittsburgh that doesn't work at, that is not an entertainer or athlete?
It depends, Your Honor, on a number of things. So, if you are a non-resident of Pittsburgh that works there but lives in the state of Pennsylvania, the city withholds the greater of the income tax that the city imposes or the income tax that is imposed by your resident jurisdiction. The city collects it, and then it allocates it based on the difference there. So if your local jurisdiction, your resident jurisdiction charges less, it provides that allocation to your resident jurisdiction. It maintains the balance. If it's greater than, it pays all of it to your resident jurisdiction, and you still owe your resident jurisdiction money. If you are a non-Pennsylvania resident, you owe a 1% income tax to the city of Pittsburgh. And I want to be very clear also.
What if you're, I mean, so here's my concern about this special taxation for entertainers and stadiums. And the hook seems to be that they're publicly financed facilities. At least that's the hook that the General Assembly seemed to come up with. Courthouses are publicly financed facilities. Hospitals, to many degrees, are often publicly financed. Airports are publicly, I mean, we could go down the publicly financed road. Is it constitutional then if the General Assembly wanted to sort of piggyback off of this framework and create a very similar law for attorneys that are not living in the city of Pittsburgh but come in and appear in courthouses or buildings. Would that be a constitutional framework?
Under the uniformity clause, Your Honor, if the overall tax burden on that class of individuals, lawyers that appear here, is equal, it would be, so long as there's enabling state legislation. Now,
Okay, so we can treat professions from a taxation perspective differently.
no, Your Honor, I'm sorry, we're looking at the uniformity within a class of subjects. So in the facility fee, that class of subjects is the earned income made from performances at those facilities. And there's no...
And the earned income we're talking about is the earned income made by lawyers who appear in courthouses.
Certainly. In that instance, there may be a uniformity issue between lawyers and non-lawyer, non-athlete.
Well, that's the classification I'm getting to.
Oh.
I'm trying to understand. We're not allowed to classify or change classification based on how much money. We know that's the law. You can't
Correct.
do it by money. I'm wondering whether you can constitutionally do it by profession.
You can constitutionally do it based on legitimate business and policy-related reasons. And there's only...
What's your source for that? I mean, what's
The only case related to...
the hook here is it's a publicly financed facility.
It's the athletes and entertainers that perform there. And the hook there is, from a business and policy perspective, and there's really only one case in the nation on this, and it's out of Ohio. The court has said in the Hillenmeyer case, when you look at the justifications and rationale for treating athletes and entertainers differently, they demand a greater amount of resources for security and safety and traffic control and police protection, and stress on the local infrastructure.
Sounds like judges.
Exactly, Your Honor. There's about as many people in here as there were at the 13-inning game last night here in Pittsburgh, right? So, in any event, those real-world considerations and those real business considerations can be used for classification. Classification, in and of itself, is not prohibited. If there's classification, there needs to be a reasonable, rational basis for that classification.
And that's why not everybody that works at our sports stadiums falls into this. This is just athletes, entertainers. This isn't the guy selling the beer or the popcorn.
That's correct, Your Honor. It's athletes and entertainers that perform at those stadiums, and that's defined in the local code, that have the 3% tax burden on their earned income.
And only the non-residents.
Only the non-resident, athletes and entertainers.
So the city's claiming then that tax is necessary, in effect, to cancel out a different tax, the school district tax that only residents of the city of Pittsburgh pay, right?
I don't think it's so much as canceling out, but it is equalizing the tax burden, because if you are a resident athlete or entertainer, right, and in our class here are athletes and entertainers. If you are a resident athlete or entertainer, you live in the city of Pittsburgh, you perform at one of those facilities, you are taxed 3% on the income generated there. Now, with the facility fee, if you're a non-resident, if you live in one of the suburbs, if you live in Philadelphia, if you live out of state, you also get taxed 3%. Now, what happens after that money is collected is different, but that's never been a determinative of a uniformity clause challenge.
Doesn't it look a lot like what the court put the kibosh on in that Johnstown tried to make the same move in the Daniluk case?
It's very different, Your Honor. And let me go through those distinctions and why Daniluk does not apply here. There was only one taxing entity in Daniluk. It was the city of Johnstown. So if the city said we've got a 1% and let me back up, there were two different types of taxes. So the subject of the tax was completely different, right? So if the city of Pittsburgh said we're going to tax residents 3% on earned income, and we're going to equalize that burden on the non-resident athletes and entertainers by taxing them 3% on the value of any real estate and assets they hold in the state of Pennsylvania, that would be a different case, because the subject of the tax, which is what the uniformity clause looks at, is different. And that was the case in Danny Luck. In Danny Luck, there was one taxing authority, two different types of taxes, a head tax and an occupation tax. There was, and the main holding in Danny Luck was that the head tax on non-residents was per se invalid. Why? Because the purpose of a head tax is to provide revenue and resources for services specifically for residents, right? So the subject of a head tax are residents. Non-residents cannot be subject to a head tax. And any discussion on uniformity in Danny Luck was dicta, as indicated by this court in the Leonard case. It reaffirmed the fact that that the head tax was per se invalid on non-residents, with dicta related to the uniformity clause if there were an occupation tax set on both, because occupation taxes are different than earned income taxes. So the two cases that are most factually similar to our case, Minnick v. the City of Sharon, and even more so, Frey out of Maryland. There you have two taxing entities equalizing an income tax burden on non-residents that facially calls out non-residents. In both cases, this court and the Maryland Supreme Court upheld those special non-resident taxes because the overall tax burden was the same.
I'm still trying to understand this overall tax burden being the same for non-residents. I'm not talking about non-resident. I'm sort of focusing when I hear non-residents of Pittsburgh, not someone who lives in California who's coming in for an event.
Sure.
So let's assume the Pittsburgh Steelers draft a quarterback. That quarterback's going to have an option. Maybe move into the city of Pittsburgh, maybe move into Washington County. If that quarterback moves to Washington County, is that quarterback going to pay 3% to the city?
Yes.
Even though they may be paying 3% to Washington County and their local school district?
Here's the distinction, Your Honor.
Just the answer first, then you can give me a distinction.
They may not be paying that 3% to Washington County or the local school district. And if they are, there's a credit option. And I want to be very clear. This income that is generated, let's take that example. The income that is generated at those facilities is taxed one time, right? So if that quarterback goes and plays the Cleveland Browns or the Cincinnati Bengals or the Baltimore Ravens, those cities will capture the income generated there and charge income on that earned income. So the resident city or county or school district they live in, unless their statutes say something different, can't capture income generated outside of there. And if they can, that's where the credit comes in. And I know there's been discussion on, this doesn't allow a credit. The city has now conceded this is an earned income tax, so it's eligible for credit purposes just like any other earned income tax.
Tell me how the credit works.
Certainly. So the general purpose of a credit is so you're not taxed twice on income earned at a particular location.
Where do they get the credit?
They would get it depending on how the local ordinances are. Generally, they will receive it against income paid to their local residents. So if
Are you giving them the credit? Is the city giving them the credit?
Yes.
Okay, the city is giving them the credit.
Yes.
Just as you do with residents.
Correct.
Credit for their school district earned income tax.
Correct. Now that the city has conceded this is a tax, it will be an earned income tax. It would be treated as such. And again, Your Honor, to go back to both Justice Bronson and Justice Donahue's questions, it's going to depend on where that person resides even in the state of Pennsylvania. Philadelphia has a completely different local income tax structure. Other places don't have school income taxes. Some are higher than others. Some don't allow a credit, some do. And that's why the uniformity clause looks at the territorial limits of the taxing authority. So that is, the key is the city of Pittsburgh. We cannot control everything that happens outside the city of Pittsburgh. And that's been discussed by this court in the life insurance of Pennsylvania case, where non-resident life insurance companies, foreign life insurance companies, complained that there were other taxes that they were subject to in addition to the 2% tax in Pennsylvania that domestic life insurance companies were. And the court said, there's never going to be perfect uniformity. In the state of Pennsylvania, everyone pays 2%. That is an equalization. If you have to pay taxes other places for other things, that is part of our taxing system.
But again, I'll go back to my point, I'm not trying to belabor it, but in the city of Pittsburgh, the only non-residents that have to pay the 3% are non-resident entertainers for the income they earn at a publicly financed facility.
That's correct. There is a separate classification of non-residents and non-resident athletes and entertainers.
And the General Assembly, in your view, has the power and the authority to continue to do that kind of classification based on job and location where they do their job.
Based on the real-life business interest, yes. Based on the business.
Valid classification, your profession, and where you do your profession.
Depending on the profession and depending on the real business implications behind that profession. So again, the court in Hillenmeyer out of Ohio, the only one that's opined on whether athletes and entertainers can be a classification of their own, has said there are real-world implications that allow you to classify athletes and entertainers differently than others.
Mr. Ashwagi, you are admitted here pro hoc vice from Columbus, Ohio.
Yes, Your Honor.
Correct. Could we tax you a little bit extra?
I'm sorry?
As a pro hoc vice attorney from out of state?
If there is a legislative enabling act that allows you to tax income here by me appearing pro hoc vice, absolutely. But for the record, I do pay taxes to the city of Pittsburgh because we have an office here and we generate income here, and therefore the apportionment of my income.
Because you're a partner at the firm.
Correct. Apportionment of my income that is citist to the city of Pittsburgh, we pay local income taxes on that. We pay state taxes and other taxes based on.
School tax?
I do not believe so, Your Honor. Yeah. I wish I were an athlete or entertainer. I would.
I thought you were going to argue that you were neither athletic nor entertaining.
Yeah. It's probably also true, Your Honor. So.
Isn't that because having a law firm here in the city, you have a larger intensity on the municipal services that the city offers?
Certainly, but Your Honor, the earned income tax, and again, I go back to the language of the uniformity clause, and it talks about equal burden on the subject of the tax. The subject of the tax here is the earned income. So the benefit of earning that income is really what's being taxed. This is not necessarily a benefits or a privilege type taxation. We earn income and we pay taxes on it.
Is the credit difference on earned income tax as opposed to the taxes paid by the school district? And the reason I ask the question is because I know the enabling statute, the legislation for the school district doesn't allow the school district to apply an earned income tax credit, earned income tax. So isn't what we're talking about here really an attempt by the city of Pittsburgh to kind of evade that prohibition in the school tax? Because my thought process is when you pay taxes, there's a burden, but there's also a benefit. If I'm an out-of-town athlete or entertainer, I don't get any benefit for that 3%, whereas somebody in the city of Pittsburgh who's equalized gets the benefit of the school district.
Your Honor, this goes to the benefits theory. So first, I will say that because the subject of the tax is earned income, this benefits theory or privilege theory doesn't apply. In fact, and that's briefed in our case. So in the Airway Arms Inc. case, Taxpayers may not successfully object on the grounds of the benefits theory to taxation for a general public use, which includes taxes for schools.
Let me back it up to my original point, which was the school district isn't allowed to impose an earned income tax. It's based upon your residency status, correct?
The school district is permitted to impose an earned income tax on residents of the school district,
When
correct?
we talk about 3% and 3%, isn't this really just an attempt to kind of evade that prohibition?
It is not, Your Honor. It's, again, and the uniformity clause has never, and this is this is the key point here. It is not determinative of who levies the tax. You look at the subject of the tax. This is a single tax. It taxes income. It is a public benefit, whether it goes to the schools or if it goes to the city. And whether or not you get any direct benefit from the schools is also not determinative of whether the equalization of the overall tax burden meets the uniformity clause requirement. There are a number of individuals and families that pay the school income tax that don't receive a direct benefit from the schools. But there's a general benefit, as this court has stated and has briefed from a well-functioning, educated society that is also a general indirect benefit that is enjoyed by non-resident athletes and entertainers. At the end of the day, Your Honors, this is a rational basis, highly deferential review of the facility fee under the plain language of the uniformity clause, which requires equal or uniform tax burden on the subject that's being taxed within a particular class. Here we have a class of athletes and entertainers. The subject of the tax is their earned income at these facilities. Not only is the tax burden not disparate, it's identical. Again, regardless of where you live, there will be 3% withheld from your paycheck for money made in the city if you're an athlete or entertainer. The state enabling statute permits this tax. The city didn't do this unilaterally. That state enabling statute still stands, has not been challenged. There's a presumption of constitutionality. There's a heavy burden to strike down this statute. And if there's any doubt whatsoever, it should be upheld.
All right.
Thank you, Your Honors.
Well argued. Let's hear from Mr. McManus. Also pro hoc vice from Boston, I believe.
Correct, Your Honor. Madam Chief,
You get rich today.
We could.
Madam Chief Justice, and may it please the court, Ryan McManus on behalf of the Players Associations and the individual plaintiffs, and with me at council table is my colleague Stephen Kidder. Your Honors, this is a special tax applicable to non-residents only of only particular professions. It is not uniform, and the city's entire argument to the contrary rests on a false equivalency. There's no disputing that a 3% tax on non-residents isn't equivalent or even roughly equivalent to a 1% tax on residents. The city tries to manufacture uniformity here by pointing to the 2% tax to the school district that residents pay, that separate burden that residents pay for school district taxes. Now, of course, non-residents also pay school district taxes wherever they live. City ignores that, doesn't factor into its calculus at all.
They may or may not, depending on the tax structure of their resident city or borough, right?
Correct. They pay to fund schools where they live. Depending on the structure, it may be a separate school district tax, it may be county taxes. But for example, non-residents of Pittsburgh.
They pay it in Pennsylvania.
Exactly. They pay it in Pennsylvania. If you reside in the suburbs, you're paying a school district tax there.
And you're getting a credit.
Sure.
You're not getting a credit under the facility fee. That's really important, and I want to clarify that. You're not getting a credit for two reasons. One is, despite the city's admission in litigation that this is a tax, the city's facility fee regulations still instruct that you are not to list the amount paid in facility fee on your W-2 in the local tax box because, quote, this is a fee, not a tax.
That's got to change since they're acknowledging it's a tax, right?
Your Honor, they acknowledged at the Commonwealth Court that that regulation would change. It hasn't. It still reads exactly the same. But that's not the only issue with the credits. The other issue with the credits is that the city is arguing not that non-residents are entitled to a credit against the facility fee that they pay to Pittsburgh for taxes that they pay where they live. They're arguing the opposite. I think I heard different today, but I'll point you to the city's brief. On page 26, they say non-residents living in Pennsylvania are owed a credit for the facility fee against earned income taxes they owe their home community. They're arguing that it's the jurisdiction of residents that should be giving a credit. They're not giving the credit. Now, that's backwards as a matter of state law. The statute provides that you are entitled to a credit in the place where you work for taxes paid in the place where you live.
I mean, I'm confused then, because I thought what your opposing counsel was arguing was that the city of Pittsburgh processes the credit, not that they give the credit.
I may have heard it differently, but it's not a question of processing or the mechanics of it. The question is really, where are you paying the tax and where are you entitled to take a credit? Pittsburgh is not giving credit against facility fee taxes that are paid by non-residents. What they're arguing in their brief is, go claim a credit where you live.
Right.
There's no statutory basis for non-residents to claim a credit where they live against facility fee taxes paid.
The local government may say, well, the regulation says it's a fee. I'm not going to give you a credit for a fee. And,
Correct.
And you know, they may have a problem with it.
And it's not listed on your, it shouldn't be listed on your W-2.
So as you understand it, at the end of the tax year, there's no form that non-resident entertainers can file with the city that says, this is what you have withheld on your 3% EIT. Here's what I pay locally for school taxes. Give me a credit and give me a refund. There's nothing like that.
Correct. There is nothing like that. So again, the disuniform credits is a significant problem here. It is not the only problem, but I want to be clear. Pittsburgh is not giving credit to non-residents for the school district taxes or earned income taxes those non-residents pay where they live.
Which goes to my...
I understood that, but I guess what I'm having trouble with is that there seems to be some lag in characterizing this through W-2s and what other forms they're generating out of the city of Pittsburgh, now that the city has admitted or acknowledged that it's a tax, not a fee. I'm concerned somewhat that is not actually, that there's not necessary follow-up to that admission.
And it requires, Your Honor, not just a change of the regulations and a change of the guidance, but Pittsburgh needs to change its position as to where this credit can be taken. Pittsburgh needs to be giving the credit, not demanding that the jurisdictions where athletes reside give the credit.
Well, I don't understand that, because it is up to the jurisdiction where they reside ultimately, isn't it?
Well, by law, by Pennsylvania statute, you as a taxpayer are entitled to take a credit for taxes paid where you live against taxes paid to your place of work. So that's what the statute provides. They're saying that it should be the reverse here.
Right,
They're saying,
right.
and again, that position is not consistent with statute. I want to point out also another issue, in addition to the credits, that the city's...
Pardon me, counsel, was this issue argued before the Commonwealth Court? What was the city's position when this case was argued before the Commonwealth Court? Were they still claiming that it was a fee, not a tax?
No, they had conceded that it was a tax.
In the Commonwealth Court?
They conceded it in the briefing before the Court of Common Pleas. Okay. That was where they first conceded that it was a tax.
Okay, so this has been their revised position, so to speak, for a long time, and it's essentially always been their litigation position.
Their litigation position has always been that the regulation needs to be changed, as I understand it. They acknowledged that before the Commonwealth Court. But their position has also always been Pittsburgh doesn't need to give the credit. It should be given elsewhere. It should be given where they reside. And they never cited anything in support other than the fact
Doesn't that make sense? I mean, because how is Pittsburgh going to give the credit to, with 20 other jurisdictions at issue here? Wouldn't it always fall to the home residence jurisdiction to give that credit?
It does not, Your Honor, by law. And for all other wage earners who earn income in Pittsburgh, who pay local taxes where they live, they are claiming a credit against Pittsburgh's tax, and that Pittsburgh is not ultimately retaining that because they have to give the credit. So that is how it works elsewhere.
If the city imposed a 3% tax, facility tax on everyone, and the Pittsburgh School District had given credit for that 3% for residents, would that violate the uniformity clause, or would that be uniform?
If it gave uniform credits to everyone, then I think that what you're describing would be very close to what the court was addressing in Minich. If you have a uniform tax at a uniform rate applicable to everyone, residents, non-residents, athletes, and other wage earners, right? There's two critical distinctions here that are being made. If you had a uniform tax like that and everyone was uniformly given credits, then I think this looks very much like the Minich case, and I would acknowledge that. But that's very different from what the city has done here. This is not a uniform tax. And I want to make clear that
When you say has been done here, they aren't collecting this tax now. I mean.
they are collecting this tax.
Okay, and so we know definitively that no credit is being given for income taxes paid in the athlete's home state or home municipality.
We don't know that.
I don't know that,
Well,
and
then I thought that's what you just said.
what I'm saying is by law, there's no basis for someone to claim a credit where they live. The
But we
statute
know,
wouldn't
but
allow
we
that.
know. I mean, that's why I asked the question. I mean, if this tax is being assessed now, there's evidence as to how this works. Why don't we know that? Why don't you know that?
Well, all we know is what the law would permit a taxpayer to claim. And the law wouldn't permit them to claim this, so I
Why
have.
doesn't your client know the answer to that question? I mean,
Our clients have not attempted to claim credits where they reside because they don't believe they have a statutory basis to do that, and because they're not listing this on the W-2 because they're following the city's regulations. So they are not claiming credits where they reside. There may be some athletes that we don't represent that are doing that, but our clients are not claiming credits where they reside because they don't think they have a legal basis to do it.
and that was on your advice.
Not my advice personally,
Yeah,
but
well,
they're working with their personal tax advisors as well.
legitimate question whether he advised them on what the law was.
I also want to point out, in addition to ignoring the taxes that non-residents pay where they reside, the city is also ignoring that school district taxes that residents of Pittsburgh pay, by law, cannot be imposed on non-residents, and therefore can't justify this separate, even if equivalent, burden that they're trying to put on non-residents.
That was sort of what I was trying to get at earlier. It seemed like an apples and oranges problem. Am I right about that?
You're exactly right.
Under this enabling statute, could there be any facility fee that you could envision that would be constitutional?
It would have to be a true fee. I think it's important to keep in mind, the legislature did not authorize a tax. And that's a problem the city's also never grappled with. The legislature authorized a fee. That's significant as a legislator. Whether you're going to enact a tax or not is a significant political decision. They authorized a fee. The city has now conceded that what it's imposed is a tax. And it's a tax in excess of 1%, by the way. State law limits taxes on wages to 1%. They've never explained how they can tax this class at 3%.
Well, I think that the General Assembly sort of knew that what they were doing here was dicey. They called it a fee, even though they put it in the Local Tax Enabling Act. And they specifically referenced on-earned income and percentages, which look like a tax and not really a fee. And if it's a fee, then they run into the other problem, which is you're going to have a challenge to the fee. Is it reasonable? Is it, and the argument would be it would be a tax. Everybody knew this day would come, is kind of what I'm saying.
I think that's right. I think hypothetically, however, under this enabling act, Pittsburgh could enact some type of fee that could withstand uniform. Correct. Something related to the costs of, regulating professional athletes to the extent that they do. And I think, just getting back to the apples to apples or apples to oranges comparison, that's really the correct way to analyze uniformity. It has to be an apples to apples comparison. The question is, with respect to a particular tax burden, are taxpayers similarly situated? If they're similarly situated, then the burden has to be uniform. If they're not similarly situated, then you don't weigh those various burdens against each other in a uniformity analysis. That's why a property owner in Pittsburgh can't be heard to object that their neighbor who doesn't owe property pays less tax. They're not similarly situated. So that property tax burden isn't going to be considered in a uniformity analysis. For the purpose of school district taxes, residents and non-residents are not similarly situated. By law, non-residents can't be charged with school district taxes. And as to the benefits, I understand, council's argument about not pointing to the various degree to which people benefit from city services. The benefits here are qualitatively different. It's not just a matter of degree. Residents can send their children to public schools, non-residents cannot. So, and that's been codified by law, by prohibiting Pittsburgh and other municipalities from taxing non-residents with school district taxes. So you can't look at school district taxes as sort of a justification to impose this 3% tax on non-residents. That's apples and oranges. You've got two apples on the scale, and then Pittsburgh's adding an orange. That's not appropriate.
Isn't that minutes?
No, it's not mintage, because mintage, you had a uniform tax at a uniform rate. I don't agree with the contention by council that mintage had two different taxes. It was a 10 mil tax applicable to residents on all of their income and applicable to non-residents on the income that they earned in the city of Sharon. So you had a uniform tax at a uniform rate, and you had credits that were uniformly available to everyone. The issue in mintage was that residents of the city of Sharon were paying a 5 mil school district tax, and they were claiming a credit for that tax. The plaintiffs in that case were not paying any school district taxes where they resided, and therefore they weren't entitled to claim a credit. There was no distinction being made by law. The distinction was in the personal circumstances of the individual taxpayers. That's very different here. We're not arguing that the court should overrule or narrow MNIC. It's a straightforward application of the uniformity clause. Pittsburgh has simply chosen to enact a very, very different tax scheme. And we think that the controlling case here, as both lower courts determined, is the Daniluk decision. In Daniluk, just like Pittsburgh here, City of Johnstown enacted a tax that applied to non-residents only, $10 occupation tax. And like the city here, Johnstown defended that tax by pointing to a tax on residents. It said, well, you have a $10 per capita tax on residents. But like the school district taxes here, the per capita tax in Daniluk could not, by law, be imposed on non-residents. And as a result, this court said that tax burden on residents can't justify an equivalent burden on non-residents. You're not permitted by law to tax residents with, non-residents with a per capita tax. That's what this court held in Daniluk, and as both lower courts determined, that is controlling here. That was not dicta in the Daniluk decision, by the way. It's a short decision. It's 2 pages. No fewer than 3 times does this court say in that decision that the tax is violative of the uniformity requirement. I think the confusion on this point arises from the fact that the court was trying to understand what this tax was. You've got a tax on non-residents only, and Johnstown was saying it's the same as the tax on residents. And the court said it's not the same as the tax on residents because that's a per capita tax, and you can't impose a per capita tax on residents. So this is something different. It's not the same as that, and because it's a different tax applicable to only non-residents, it's not uniform.
Could they redo the ordinance and say, try to bring it more in line with MNIC and just say, every athlete, regardless of whether they live, where they live, pays 3%. And if you pay a local school district earned income wherever you live, you can get a credit against that.
That would still be different from MNIC in that it would be distinguishing athletes from everybody else.
Well, I asked my questions about that, but let's assume that's okay.
Assume it applied to everyone?
Yeah.
Yeah, so if it applied 3% tax uniformly to residents and non-residents
Gave a credit
of any profession.
You could submit a form at the end of the tax year that says, this is what you withheld from me for this 3%. This is what I paid in local school district, earned income tax. I want a credit. Everybody did it.
If they did that, it would look very much like Minix, and I think it would be sustainable under the uniformity clause. This is very different in multiple ways. As we talked about, the credits is one problem, but also this does not apply uniformly to everyone. This singles out particular professions and charges them at a higher rate. This court has always treated wage income, which is what this tax is imposed on, as a single class. And it has always stricken down distinctions between and among wage earners. That's why it struck down a graduated income tax in the Kelly case. That's why it struck down the deductions and exemptions in Amadon. And I'll point the court to one more case. It's the Butcher versus City of Philadelphia case. It's cited in one of the concurring opinions in Amadon. It's from 1938, and it dealt with an early version of Philadelphia's income tax. And Butcher is significant because it struck down portions of the Philadelphia income tax that granted exemptions for domestic servants and farm laborers. In other words, exemptions that carved out particular professions for differential treatment were struck down. And that's what this statute does, or this ordinance does. It targets particular professions. And really what it does is it tries to use professions as a proxy for income. And it tries to impose in practice the type of graduated income tax that this court has never allowed.
You can say that. However, you have to also acknowledge that professional athletes and entertainers coming in to use our stadiums place a burden on our city's resources. Additional security, additional police, additional city services to take care of those athletes and those entertainers and what impact they have on the city. I mean, you can't ignore that, can you?
So we don't ignore that, and we acknowledge that the burdens that any profession imposes on the city are going to vary widely, and that professional athletes who perform at public stadiums certainly require an extent of city services that perhaps lawyers like me do not require. But there are many other services. For example, if Taylor Swift comes and plays not at one of these stadiums, but in a public park, that's going to impose just as much, if not more, strain on city resources, and yet she's not going to pay the facility fee for that appearance. She will if she performs it in particular stadiums. And I think more importantly, imposing differential tax rates based on the perceived burden that different professions impose on the city is really inconsistent with the purposes behind enactment of the Uniformity Clause. And this court has detailed the history of the Uniformity Clause at length in Nextel and Mount Airy. The Uniformity Clause was enacted based on the perception that particular industries were getting unfair, perhaps rational, but unfair subsidies. They were being exempted from tax laws, causing the burden to fall disproportionately on everybody else. So it's clear from the history of the Uniformity Clause that you can't say a particular industry provides such public benefits that we're going to exempt them from taxes. For example, if the city of Pittsburgh was to say, you know what, the future is AI, and we're going to exempt anybody's income that's earned for working at a data center, I think that would run afoul of not only this court's cases, but the history of the Uniformity Clause. What the city is arguing is really just a variation of that. It's trying to say, notwithstanding that you couldn't do that, you can try to consider and ascertain different burdens that different professions are placing on the city and tax them differently because of that. And I'd submit that that's the same as trying to weigh the various benefits that different professions or different industries are conferring and doling out preferential or non-preferential tax treatment based on that.
Okay, we understand the argument. Is there anything you'd like to say in summation?
Can I ask you a question before you sum up? And I really should have asked opposing counsel this question. Where in the record, if anywhere, can we determine the manner in which credits will be given or are being given to your clients?
Sure. So I'll point to, first of all, the state law on credits, which governs where that they can be claimed.
I understand the law. I'm asking for where in the record can we determine what the city is doing?
I'm not sure that there's going to be anything in the record regarding what the city is doing beyond what it's arguing in its briefs. I can point you to the existing regulation.
We know that.
We know that.
Okay.
Yeah,
I think the only,
I'm looking for facts.
I don't think there are facts in the record about credits being denied per se, because again, no one has claimed a credit they don't think law entitles them to.
All right, thank you very much. Although, counsel, and very well argued, although we do not permit rebuttal in this courtroom, I am not precluded, a justice is not precluded from asking a question in the nature of rebuttal. Mr. Ashwayi, can you enlighten us as to whether the city of Pittsburgh has amended its forms, created new forms to account for this acknowledgement by the city that this is indeed a tax, not a fee? And if not, why not?
To the best of my knowledge, Your Honors, because to Justice Donohue's point, there isn't anything in the record related to the handling of credits.
How do we decide this then? I mean, when you rely so heavily on MNIC, which involves credits for earned income tax paid, to another source.
Sure.
And there are really two questions, the credits and that Justice Donohue's concerned about, and also just the characterization in your processing procedures and in your forms as to whether it's a tax or a fee.
I think there are a number of questions, so I will start with Chief Justice Todd. To the best of my knowledge, the regulations have not been amended, and there have not been creation or at least finalization of new forms. The reason for that is because this court could do any number of things, and so the city was waiting for some finality on what this law may or may not look like at the end of the day, and what parameters may or may not be imposed on the law.
That's a good answer.
Thank you. I thought so too.
Okay, could you answer Justice Donohue's question?
Yes, and your question was, how can we decide this case if
we don't know what you're doing in order to effectuate a credit for earned income tax paid somewhere else?
The answer to that question directly, Your Honor, is we will comply with what the laws say in each of the respective jurisdictions, because different jurisdictions have different credits. And so, and to take it one step further.
Given a credit here. I thought I asked this question.
You did,
indirect.
and that is exactly what I said. To the extent that it requires to give credit where you work, credit will be given here. But I want to be very clear. The way professional athletes and entertainers are paid, unlike us who receive salaries, they receive compensation, entertainers, based on where their concerts are. So when Taylor Swift performs here and makes $20 million, she's not paying taxes to Nashville, Tennessee, because that income isn't generated there. That's why there can never be perfect uniformity, and that's why you need to look at the territory.
I have to follow up on this line of questioning, which in this rebuttal situation, you can't tell us. I mean, are you telling us that there is a way for us to uphold this under the promise or guise or possibility that the city is going to amend its regulations, its forms, and allow a credit that heretofore they have never seemed willing to provide?
Certainly, Your Honor, the city is going to comply with the law, which requires credit to be given.
But the statute and the regulations and the forms don't allow this. And that's what's in front of us. It's not the scheme that you could craft that could pass constitutional muster. It's what's in front of us now. And right now, your regulations don't allow any declaration as a treatment as a tax. That's the scheme that's in front of us, not some hypothetical other scheme that you might be able to craft. The solution would be for us, if we say it's unconstitutional, is to strike this one down and let the city try to craft a new one that might comply with our decision.
Sure, Your Honor, I would respond to that by saying, again, I believe the credits are a little bit of a red herring, because in the city of Pittsburgh, you're paying no more than 3%.
I understand, but my simple point is you can't promise us the city is going to do anything. We have to deal with what's in front of us now, not what's hypothetically in front of us.
Correct. And what's in front of you now is the city has acknowledged this is a tax and will be treated as such. And
You've acknowledged in this litigation.
That's
you have,
correct.
But your regulation, which your city is bound to follow until it's repealed or declared unlawful, says otherwise.
And I would conclude with, Your Honor, even under the current regulation, which does not allow a credit, because within the city of Pittsburgh's territorial limits, which is in the plain language of the uniformity clause, within that territorial limit, all athletes and entertainers pay not a roughly uniform tax burden on income, the exact same tax burden on income. What happens outside of the territorial limits of the city of Pittsburgh is not a concern or determinative under the uniformity clause.
Okay, this is unusual for us to do, but I'm going to request further briefing on this last issue, on the issue of what the city has done and what it has not done and why, with respect to this being an acknowledgement that this is a tax, not a fee, and also the credit issue, how it's being handled and how it should be handled, what the impact is legally. And I'll ask our prothonotary to set an expedited briefing schedule. We want to get this right, and I think it's important that we understand your positions on this issue. So thank you very much, both of you.
Thank you, Your Honors.
Well argued by both sides.
Sure was. Thank you. I'm here. Mr. Minner? Yeah. Call the next case, Mr. Minner?
Commonwealth of Pennsylvania versus Sheldon Gidor, representing the Commonwealth, Mr. C. Sean Dreyer, representing Mr. Gidor, Mr. Corey Fields.
Oh, actually, we have them all. Yeah. I use my sleeve.
Good morning.
Good morning.
In this case, Apelt was convicted of first-degree murder. Following his conviction, he filed a motion for an evidentiary hearing regarding whether one of the members of the jury had been subjected to outside influence. As support for his motion, he attached an affidavit from one of his trial attorneys, Alexis Cobb, wherein Ms. Cobb stated that she spoke with Ralph Smith. Smith told her that following the trial, Smith had a conversation with Chris Gabor, the father of one of the jurors, and that Mr. Gabor indicated that his daughter, the juror, was allegedly having difficulty with the case and that he and his daughter preyed on her decision before the jury rendered its verdict. The trial court denied Apelt's motion, finding that Ms. Cobb's affidavit, which consisted of several layers of hearsay, was not competent evidence to warrant an evidentiary hearing. The Superior Court reversed the trial court's decision and held the trial court abused its discretion in this regard. In the appeal by the Commonwealth, we consider whether the Superior Court erred in concluding that the trial court abused its discretion and in reversing the trial court's order. Please proceed.
Madam Chief Justice and Justices of the Court, may it please the Court, my name is Sean Dreyer. I'm an Assistant District Attorney in Beaver County. I'm here with my boss, Nate Bible, our District Attorney, to explain to this Court why the Superior Court should be reversed and the grant of the hearing be reversed, and the trial court's denial of an evidentiary hearing in this case should be affirmed. Your Honors, I believe that the issue in this case can really be viewed under two different lenses, one a substantive one and the other one a procedural one. I think the substantive question is, what showing does a defendant who's been convicted, and that conviction is supported by the evidence, what type of showing does such a defendant have to make in order to trigger an evidentiary hearing that would require the jurors from that case, or at least one of the jurors from that case, to appear, be examined and cross-examined in a formal proceeding? The other question, the procedural lens that should be applied, is whether or not the trial court answered that question in a way that was manifestly unreasonable or otherwise constituted an abuse of discretion, or, to the contrary, was that decision fully supported by the record. With respect to the substantive issue, that is to say, what does a defendant have to provide or show in order to trigger a hearing, I believe that the answer was provided and among other cases, the cases that the Chief Justice wrote when she was a judge on the Superior Court, Commonwealth versus Messersmith, which says it is only in clear cases of improper conduct by jurors, evidenced by competent testimony, that a verdict which is fully supported by the evidence should be set aside and a new trial granted. I'd note that that standard comes from a case that really, in 1934, Friedman versus Rolfe Brothers articulated the same standard. So it's been nearly for a century that it's been clear that that's what, in this type of circumstance, a defendant needs to do.
How do you reconcile, I guess you can find language, well, how do you reconcile that with the fact that trial judges all the time make discretionary assessments, decisions to afford an evidentiary hearing when counsel bring to the judge's attention certain allegations or averments? There's discretion in Pennsylvania for common pleas judges to order an evidentiary hearing. It happens every day across all areas of law. And then it's at that hearing, if the judge decides to give that hearing, that the test comes in as to whether there's competent evidence. In other words, this barrier you're trying to declare or validate here is that the admissibility has to be determined prior to even getting an evidentiary hearing, and that seems at war with the way law is practiced in Pennsylvania. I mean, I think it would be a surprise to judges across the Commonwealth.
Well, my answer to that, Justice Wecht, is that in this particular instance, in the particular posture of this case, there's already been a verdict. There was a 3-day voir dire, a 7-day trial, and I think probably 1 day of deliberation stretched over 2 days, where the case had been thoroughly explored, the case had been tried, the defendant was afforded the full panoply of rights that all defendants are afforded under our Constitution, and a verdict was issued. A verdict was issued by a jury beyond a reasonable doubt. And that verdict has some degree of sanctity, if you will. I believe that's...
I just interrupt. I mean, I think we all understand and respect the sanctity of a jury verdict. That's a given. I thought the question was whether there is some gold standard that says, because if we say it, it's going to be a new standard, that judges in Pennsylvania cannot order an evidentiary hearing if in their discretion they think one side or both sides have made a showing that they should be able to develop evidence they say is out there. I mean, because motions courts in Pennsylvania, civil, criminal, family, they order hearings every day when they decide a party should have an opportunity to lay down a record.
Well, I would respectfully submit, Justice Wecht, that this is not a new standard, that it may be a clarification of what the standard is and has been at least since 1934. But in a situation where one party is attempting to overturn or bring into question a verdict of a jury, they have to have something. If they don't have to have something, competent evidence that shows some possibility of prejudice, I believe that is the standard.
Well, counsel, you keep saying you keep referring to competent evidence. I mean, the only incompetent evidence in this situation would be evidence that was proffered to show what happened in the jury room. Otherwise, if the affidavit alleges facts that would support a conclusion that there was outside influence, that would be competent evidence. I mean, competence is defined by what's permissible. What's not permissible is somebody alleging that juror 1 said this to juror 2 in the jury room. That would be incompetent. Here, this is outside influence.
That would be one example of incompetence, Your Honor. I believe under Rule 602 of the Rules of Evidence, it requires one standard of competency, or one requirement of competency is firsthand knowledge. And in this affidavit,
Where do you get that? I mean, what affidavit isn't going to have hearsay? I mean, there was hearsay in all of the cases that we've dealt with before this situation. Hearsay is a rule that comes into play at a proceeding. So if a judge decides to have a hearing on this and somebody takes the stand and says, he told me that she said, that's hearsay. They aren't going anywhere with that. At a hearing, somebody would have, with direct knowledge, would have to appear on the stand and testify. But an affidavit is always going to contain hearsay. It's hearsay. The affidavit is hearsay.
if I could just respond to the 2 points. I'm not sure that, I mean, if the lawyer in this case had actually spoken with the father, as opposed to merely with the soon-to-be ex-father-in-law, who supposedly reported comments from the father. If she had gone to the father, which she could have done, and that Carter case doesn't...
About levels of hearsay. You're saying there's too much hearsay in this affidavit to allow the court to make a discretionary decision that he or she wants to hear evidence.
I'm saying that there is 3 levels of hearsay in this particular affidavit, and I would contrast it. Your Honor said that all the cases had hearsay. I don't believe, Your Honor, with respect that the Pratt case, that the letter from the juror in Pratt was infected by hearsay. In that case, the juror reported what she observed in the deliberation room, specifically the fact that other jurors had introduced evidence from other medical professionals that they had consulted, and she said this appears to have affected the verdict. So I don't know that that is hearsay, at least in the same sense in which somebody supposedly told their father, who supposedly told the soon-to-be ex-father-in-law, who told me whatever was supposed to be said.
Isn't that, aren't you conflating the standard for getting an evidentiary hearing with the standard for getting a new trial? I mean, it seems like you're front-loading this to the extent that you would foreclose the evidentiary hearing in service of denying the new trial. We're not there yet.
So I think you're right, Your Honor. So the question is, what does the defendant or the disappointed litigant have to show in order to get there? Or is this type of hearing, this type of evidentiary hearing, supposed to be granted in every case, or in many, many more cases, which is what I believe you will see come about if you make it easier?
This would happen in many cases. I'm sorry to interrupt. I mean, this is a very peculiar situation, isn't it?
Well, this is peculiar, but the notion that defendants who have lost a trial and are facing life in prison are going to grasp at any possibility to get out of that situation, that is not unusual at all, Your Honor, in my view, respectfully. So I think that, and this goes, Mr. Gidor in his brief argues that this case really isn't worthy of your attention because it's an attempt to have error review instead of affecting public policy. I think this goes to the heart of the question of whether or not this court is going to establish a system in which jurors, as a routine matter, can expect not only to have to go to jury duty and go through all the burdens that they willingly undertake. It's an impressive thing what these folks do. They're not only going to have to do that, they're going to expect afterwards people are going to call them back into court, maybe a couple of weeks, maybe a couple of years later, and question what happened either in the jury deliberation room or outside the jury deliberation room.
Isn't that argument belied by the focus of 606? I mean, 606 really limits the ability of litigants to bring jurors into our courtrooms for evidentiary hearing on what went on in the jury room. It really focuses on two limited prongs, one being when the
Well, there's two standards. There's prejudicial information not of record and beyond common knowledge and experience, or an outside influence brought to bear on any juror. So, again, my position, the Commonwealth's position in this case, is that a person seeking that type of hearing has to show by some sort of prima facie competent evidence that is a real possibility.
Well, I kind of align a little bit here with the other end of the bench, because I hear your arguments about the affidavit is based on the fact that it's hearsay, and truly it's layered hearsay, and could the affiant gotten a better source of information for her affidavit? Surely could, but it seems to me, isn't the way that you test it is by giving them an evidentiary hearing? Otherwise, you're gonna always deal with some layer of hearsay.
Pardon me, Justice Money. Well, again, I think if Justice Mundy, you're proposing a rule that essentially they don't have to make any sort of showing in order to get a hearing, then these hearings are going to be routine procedures attached to the end of every trial, or many trials. Every may be a bit of a hyperbole, but many trials are now going to feature this post-trial hearing about what may or may not have occurred in the jury deliberation room.
Commonwealth. So why don't you share with us, if we were to decide in your favor, what is it that we should write? Like, what is the threshold showing of prejudice?
Competent evidence of potential prejudice. That is to say, something more than this layered hearsay affidavit. And frankly, in this case, I'd like to point out that, again, the trial judge in this case not only denied the motion because of the hearsay, he also denied the motion because there's no clear statement in this affidavit that the father provided any outside influence or outside information to the juror. It's just not clearly stated. And
That doesn't matter. I mean, what it says is that the juror discussed the case with her father. I mean,
Did she discuss it, or did they pray over it?
they discussed it.
Both. I mean, the problem
both.
isn't that she prayed.
It's
The
that-
problem is that she discussed it with a third party, right?
if it's true that
That's what the hearing's for.
if it's true, that would be a problem, but it's not necessarily the type of misconduct that would warrant a new trial.
You could be right, but I mean, no one more than a trial judge would avoid disturbing this verdict more than anyone in this room. More than anyone in this room. So a trial judge using his or her discretion in this situation is going to test the adequacy of the allegations to determine whether or not this could establish undue influence. That's all the trial judge had to do here. Now, you're right, at a hearing, maybe there won't be firsthand testimony of any of this. I mean, obviously, the father would have to testify, or the juror would have to testify as to the discussions, but that's not where we are here. All we have here is a trial judge who said, well, if that happened, there's a problem here, or could be a problem here. I don't know. I mean, a trial judge, more than anyone, would want to avoid upturning a jury verdict. That's why the exercise of a trial judge's discretion in this circumstance gives me a lot of confidence.
He turned down the request for a hearing, right?
I'm sorry, Your Honor?
Overturned, yeah. He
Yeah.
was overturned.
The trial judge turned down the request for a hearing. He was overturned by the Superior Court, right?
Yes, Your Honor. Well, the only thing I would say, Justice Donahue, in response to your comment, and sort of dovetailing with the comment Justice Wecht had made earlier, is that would indeed be a new rule. That, as far as I can see, and as far as the cases that I've read indicate, there's never been a situation in this Commonwealth where the rule is you're automatically entitled to the hearing. The rule...
That's not really the basis for the reversal. I mean, the Superior Court's basis was not on the premise that, of course, we all know the reversal was not premised on the notion that litigants are automatically entitled to a hearing, because we, as much as you, would rue the day that every person convicted, automatically gets this sort of hearing. So there's no disagreement there. But the reversal here was premised on the analysis that the trial court undertook in denying.
Well,
That's what we're debating about here. That's what we're hearing you argue about, whether this sort of gold hearsay standard is the rule.
Well, and also the focus on the abuse of discretion or lack of abuse of discretion of the trial judge, right?
The Commonwealth's position in this case, Your Honor, is that in point of fact, although the Superior Court said that the lower court judge, the trial court judge, abuses discretion in denying the hearing, they did not in fact apply that standard. They did not discuss what the judge actually held.
They just disagree. Your argument is they just disagreed with whether or not the hearing should have been granted, rather than demonstrating how the trial judge abused his discretion.
Right, and the standard for abuse of discretion, as the court is well aware, is exceedingly high. It's manifestly unreasonable. It's not applying the law or applying the wrong law or showing evidence of partiality, bias, or prejudice. And the standard is that if there is support in the record for what the lower court judge did, then the appellate court, including, although I say it with some trepidation, this court, should not overturn that decision in the absence of an abuse of discretion.
Which is an error of law. An error of law is an abuse of discretion. And I think that's sort of implicitly what the Superior Court was talking about, that there was an error of law.
But they didn't point out what the error of law was. They said there was an abuse of discretion without going through I'm sure it's a somewhat laborious task to explain what exactly the trial court held and why it was manifestly unreasonable. They didn't do that.
I'm sorry to interrupt. I thought, counsel, it was that under Rule 606B2, juror number three would clearly be competent to testify to that, and that in a case of this gravity, the court ought to assess whether this in fact occurred. This little like prayer together session with an outside person.
Well, it depends, Your Honor, with respect on what prayer means in this context. That might mean different things to different people.
I think it matters.
No,
I
it's
think
prayer
the
with
fact,
another person.
I think the fact that there's another person
the point.
is the problem.
Well, that may be misconduct, but it's not necessarily the sort of misconduct that would entitle the defendant to a new trial, unless there was some demonstration that the father or some other party provided information or some external influence on the juror.
That prejudiced the juror, right? The prejudice
That I think, in addition to showing that there was external influence, it had to be prejudicial, and I think those are two separate requirements.
Well, the affiant said that Mr. Gidor, and this is quoting from the affidavit, the affiant states, Mr. Gidor and Mary talked about the case. They talked about the case during the jury deliberations, and that she was having a hard time with deciding what to do, and that she and Mr. Gidor prayed on it, and after they prayed, she made her decision. It seems like the juror, at least, would be competent to testify at a hearing under 606B2.
Oh, there's no doubt that if the defendant's entitled to the hearing, which is the issue here, if he's entitled to that hearing, then obviously the juror, obviously in my view, that juror would be competent to testify to any communications she had with anybody apart from communications in the deliberation.
Not her thought processes during deliberation, but this outside.
Right. But the question is, do these very tissue-thin allegations in this affidavit rise to the level that would justify a court in calling that juror back into court now to render an account of what happened 4 years ago? Now,
Just a second. Why are they tissue thin? If true, they're not tissue thin, and we don't know if they're true unless we have an evidentiary hearing.
Well, I don't think we know what they mean with respect, Your Honor. Having,
Means she spoke with someone else, her father or any third party. They prayed on it. She can pray on it herself, certainly, but she involved a third party and discussed the case. They prayed on it together, and she then was able to make her decision. That's troubling.
I understand why it's troubling, but I would submit that, again, there is a conflation here between what is arguable misconduct, and again, it comes in various levels and various degrees, versus an outside influence. If the information or influence was all from the juror to the father.
That's misconduct, but not prejudicial. Is that what you're?
Well, it's not external influence. It's her maybe unburdening herself to her father about the problem she's encountering in the jury room.
Yeah, I mean, that you just said that maybe the court ought to, I mean, if it's garbage, the court, an experienced, any judge is gonna recognize it's just garbage but how you can just say there's no evidentiary hearing on an allegation like this in a murder case, I mean, you've got strong evidence. If you have to try the case again, you try the case again. But I mean, I don't know. I'd be surprised if many judges would deny an evidentiary hearing on a murder conviction with this kind of affidavit. And it looks to me like a pretty darn serious allegation.
Yeah, but I'm somewhat paused, and Commonwealth, share with me. The issue here is, did Superior Court substitute, I guess, its own judgment for that of the trial judge, and we're giving the trial judge great discretion in making the determination. And in that judge's determination, he felt that the affidavit that she spoke to her dad and they prayed on it there's no other evidence submitted before that trial judge to prove that there was any outward undue influence. They prayed on it. At best, they're religious.
Yes, Your Honor.
So I'm confused. What's your position with regard to the trial judge's decision? Seems like this court's kind to support the Superior Court's position when the real focus is on the abuse of discretion of the trial judge. And since that trial judge has great discretion, where did he abuse it? Do you believe he did or he did not? How do you argue this?
Well, Your Honor, our argument is that there is, frankly, if you review what the trial court said in its 1925 opinion, he very carefully identifies what the applicable legal principles are. He applies those legal principles to this case, both in terms of competency and prejudice, and concludes that both are lacking.
And that's your position?
And that's what the law requires.
The Superior Court substituted its position.
Right. And
Okay, that's good.
It's a good argument. The problem is they
Thank
have
you.
a good argument, too.
We'll see.
very distinguished counsel.
All right. Is that it?
If that's all the court wants to hear,
Oh, thank you. Very well argued.
thank you very much. It's been an honor to be
Thank you
here.
very much to the Commonwealth. Mr. Woods, you must like it here. You keep coming back.
I'm going to start sleeping in the coat room. Thank you, Chief Justice Todd Corey Woods here today for Mr. Gidor. I think the court has kind of hit on the issue here. There's a lot of questions about what actually happened, and that's why I wanted an evidentiary hearing. I wanted to be able
Tell us how
to.
the judge abused his discretion based upon the evidence you submitted and the arguments made.
Sure.
That's what we're here for, not what we believe to be what we would do if we were trial judges, but tell us what that trial judge did that was abusive.
And not what the Superior Court would do. Or
Right,
would
that's-
have done, but
right.
what the trial judge did, and did he abuse his discretion?
So the trial court determined that because this was hearsay and it didn't.
You want to raise the microphone?
Sorry. Because this was hearsay and because it did not fulsomely establish exactly what was said in prejudice, that we're not going to give a hearing. Maybe in 1999, that is a reasonable statement of the law. The problem is that we've already been through this. In Pratt, there was a letter, which is a hearsay statement.
But that was a detail. That's easily distinguishable. The content of the Pratt letter was very fact-specific. This was just that she had a conversation with her dad because she was troubled by her decision, which is a weighty one, someone's life, and they prayed on it.
But that's
I'm still confused as to where this bias prejudice is coming from.
So let me just walk through what exactly was in Pratt. So we have a hearsay letter purportedly from a juror. We have a statement in there that other jurors said to her. That's another hearsay statement.
Do we take into consideration that the hearsay from the father is that he didn't trust the legal system, so he didn't want to supply one?
Well, that's not exactly right, Justice. I'll flip this around. In this case, we have a sworn statement, which we didn't have in Pratt, from an attorney, which I think has a little more credibility than.
The losing side's attorney, right?
That's correct.
Okay, should we take that?
But we
into
have
consideration?
But an officer of the court.
an officer of the court with ethical obligations
I'm
and
not
some skin in the
I'm
game.
not saying that it's disingenuous. Should we take in the fact that the losing attorney decided to submit something about somebody who doesn't trust the system?
I suspect that Attorney Cobb would much rather have had Mr. Smith sign out an affidavit if he had been willing to do so. We have in this case, we have a sworn affidavit from counsel that father-in-law was told by father that father had this conversation with the juror. It's 3 layers of hearsay. I get it. We have the averments, and I want to be very specific. The Cobb affidavit at paragraph 11 says we talked about how she was a juror and what was happening during the trial. We talked about, paragraph 12, we talked about the case during the jury deliberations and that she was having a hard time with deciding what to do and that she and father prayed on it, and after they prayed, she made her decision. So, it is true that that is not a fulsome explanation of what this conversation entailed.
But isn't that what's before the court? The judge has to decide, based upon what you submitted, whether that's sufficient for the standard of prejudice.
In another context, I might agree with you, Your Honor. But when you look at the Pratt case, here is the language. So first of all, the Superior Court and Judge Del Sol and Judge Klein, they say, okay, we get it. We get it's not clear, and we're going to have a hearing about it. And Judge Kavanaugh dissents and says, well, yeah, it's hearsay and it's not fulsome enough. Well, he lost. And then before this court, back in 2001, Justice Saylor puts kind of a fine point on it, and he says, we acknowledge appellant's arguments. This is from the Pratt case. We acknowledge appellant's argument that Juror 10's affidavit lacks specificity in material respects, and if believed, would not establish the quantum of prejudice necessary to disturb the verdict. So it's the same thing. It's hearsay. It doesn't. All that it said was, we talked to somebody about the standard of care.
And that was a
No,
civil
that's not
case.
true.
This is a murder case.
I apologize. With all due respect, the Pratt letter, it indicates that despite a medical malpractice and the testimony of a CAT scan, that they went and spoke to their own professionals. They sought out conflicting doctor testimony. At no time did they say to their dad, I'm struggling with a life case, and he says, let's pray on it.
But we don't know whether it's conflicting. And that's stated in the Pratt case. We don't know whose ox is even gored. It may have been helpful to the party who won. It's a cipher.
But isn't that the burden of the attorney who's bringing this allegation to provide the court with the sufficient competent evidence needed for him to determine whether it's biased, not afterwards?
No, and here's why. Ordinarily, if we're doing a motion to suppress, if we're doing whatever a motion to eliminate, yes, 100%. But in Pratt, Justice Saylor goes on at some length for Justice Saylor. That means 3 paragraphs instead of 1. He says, this is a different context, and this is what I want to get to next. Here's why. We don't want attorneys or their investigators going out to a juror or going out to the juror's dad and saying, hey, we need to put competent evidence in front of the court to show, hey, we need a hearing here. Because the court has said, there's a case with an exclamation point in it that says, don't do this anymore. And so we don't want them to do it. And number 2, One of the reasons we don't want them to do it is because we want to give the trial judge control over the situation. We want to give the trial judge the ability to police the boundary between competent testimony and incompetent testimony. Because if you send that investigator out there, he's going to go to the juror and they're going to talk all about how the case got decided inside the jury room.
Which means your position is the trial judge was either incompetent or abused his discretion based upon the facts and the evidence before him at that trial, at that motion?
So it can go either way.
I'm trying to find which way to go.
It can be either one, as Justice Donahue alluded to. This is an error of law because under Pratt, this is sufficient reason as a matter of law to...
If it meets the Pratt standard of the specificity and the factual basis
Right.
that the Pratt letter, but you can easily distinguish what's written in Pratt and what's written in this affidavit.
Well, I think they're factually different, but I think they're factually identical in material respects because, again, in Pratt, we just know that they talked about the standard of care and specifics about the standard of care, but in Pratt, we don't even know who it helped. So
Let me quote from it. Beginning during the trial and continuing throughout deliberation, some of the jurors reported that they had spoken to various people, such as relatives and friends, involved in the medical profession and their personal physicians to get their opinion regarding whether a CAT scan could have been performed earlier, whether a meningitis test and a CAT scan should have been performed at the same time, and whether this was standard care for 1989. Now, you're going to say an individual who has trouble making a decision with a life or death case speaks to dad and says, I'm troubled, and he says, let's pray, is analogous to this. I'm just trying to understand the weighty issue here.
So it's not just that he says, let's pray. It's all those other allegations about, we're talking about this. So what does that conversation entail? And how does counsel have the opportunity to develop that? We don't. We're not supposed to do that.
You could have brought the father in.
We're not supposed to do that, and we can't do it until we've got an evidentiary hearing, which was what I was arguing when I was asking for the evidentiary hearing. I said, Judge, look, I can't send an investigator out there.
Can you file a petition for extraordinary relief?
This court has said I cannot do it. I can't subpoena the guy who won't sign an affidavit.
Oh, I got that.
I can't get the guy into court without a subpoena.
But you could have asked him. He may have come. He didn't trust the court system to sign an affidavit.
Sure.
But that doesn't mean he can't be invited to testify.
If we had gotten a hearing, I would have subpoenaed him. Right. I would have subpoenaed father. I would have subpoenaed juror.
Except the trial judge felt that the affidavit was not tantamount to sufficient competent evidence such that Pratt mandates.
And let me just push back. I understand.
How is that an abuse of discretion for this court to get down to say that judge made the wrong decision based upon that moment when he compared the Pratt affidavit with this affidavit?
And just so you understand, that's a very hard question for us. How can you demonstrate
Correct.
that was an abuse of discretion?
That's the issue.
Yeah.
So
Not arguing.
I understand that the Pratt affidavit is more factually developed, right? It says more facts about what the conversation was. But here's the basis of decision from Chief Justice Saylor. And he's talking about how the affidavit lacks specificity in material respects. He says, for example, Juror 10's letter is not specific in terms of whether the extra record information allegedly communicated to jurors was favorable or unfavorable to appellee's position as plaintiffs, or whether it was received by majority or minority jurors. Although the tenor certainly raises the implication that the unfavorable information was received by majority jurors. So, when there is sufficient reason, it's almost like voir dire, right? When you have it's the couple of voir dire cases that the court had a couple of terms ago is probably considering now. When there's sufficient reason to raise a judicial question, what's in here, and what is the content of these conversations? Until you have that hearing, there's no way to evaluate prejudice. You just can't do it. And if this case, the principles that the trial judge used were it's hearsay, triple hearsay, true in Pratt. It's not competent evidence, true in Pratt. And it doesn't identify objective identify exactly what the conversations were. True in Pratt. Look, Judge Del Sol thought about it. They came down. Those three things don't matter. Justice Saylor and this court thought about it. Said, well, that doesn't matter because we don't want them developing it further. We want the court developing that. And look, here's another thing I want to just mention.
Can I jump in right there?
Sure.
But that's not the limit, that's not the limit of the trial court's analysis in this case, that it was hearsay and hearsay. The trial court looked at the affidavit and said, and I'm quoting from his opinion, there is no allegation that Juror 3's father told Juror 3 anything. Therefore, there is no allegation in Attorney Cobb's affidavit that Juror 3's father provided any information to the jury that the jury did not have before them at trial. And that is markedly different than the allegation in Pratt, where there was information sufficient in that situation where the juror said there was testimony that was brought in, there was discussions from other jurors about outside medical professionals not involved in this case and what their input was on the CAT scan, et cetera, et cetera.
Sure. And if that were true, I would understand that that's a factual distinction. But it's not true.
I don't know if it's true or not, but it's your burden of proof, correct, to get the evidentiary hearing? And if it's not true, then the trial judge clearly, if it's true, what the trial judge wrote, it clearly is not an abuse of discretion. And if it's not true what he wrote, based upon the language of your affidavit, why didn't you say in the affidavit, it's my information and belief that juror number 3's father told juror number 3 something that she impacted with the jury in this case?
So first of all, I think the fair import of the affidavit is they talked about this. They talked about it. When you look at the affidavit, there's a conversation about what's going on in the case, what to do, and she's having a hard time. It's a conversation.
Let me stop you there, because I'm listening to everybody's well-made points here, but as somebody who actually presided over 40 or 50 jury trials a year and then sat on a couple hundred PCRAs on the Superior Court, if I'm listening to what your argument is, you seem to be arguing that every time these kind of amorphous allegations are made, we have to have an evidentiary hearing. And while I think everybody up here would say, well, why don't we just give it a hearing and flesh this particular issue out? The issue I'm concerned about is future cases where you seem to be suggesting that everybody gets an evidentiary hearing because of something that was said to somebody's father-in-law, which may or may not have impacted the jury. I think what we're lacking here, and what Justice Mundy and Justice Doherty are really hammering at, is the lack of specificity. You just said it yourself. It implies that there was discussion, but you don't provide any detail. You don't provide any.
It says there was a discussion, right? It says she discussed it with her father.
But there's no detail about what they discussed. I mean, other than we prayed on it.
And I agree with that. I understand the court's concern.
I'm looking for a bright line here, and you're giving me, we should just have a hearing and figure it out.
Well, I'm gonna give you Pratt, and I'm gonna give you the reason why in a second. But I'm gonna give you Pratt, and it says exactly what you just said. There's no specificity here, because the overall question is prejudice, right? Is this objectively? I'm sorry.
Are you asking us to overrule Pratt?
No. They are, because Pratt says in that passage I keep going back to, the overall question is prejudice, right? We acknowledge that the affidavit lacks specificity in material respects, and even if believed would not establish the quantum of prejudice necessary. So in Pratt, this court said, yeah, the affidavit's not specific enough to get us there, but you have a duty to investigate because in the following paragraph, Justice Saylor says, attorneys, even though it's your burden, don't go investigate. We don't want you to do that. So I can't go and write upon information and belief there was a conversation, the conversation went both ways, because I don't know that, and I shouldn't know that. I'm not allowed to know that. So I understand this is a slightly different pleading standard than it is for just about every other motion there is in the Commonwealth of Pennsylvania.
Let me ask you this, Mr. Woods. under Carter, is the standard for establishing prejudice going through the analysis of Pratt that the juror took this information back to the jury, or simply that this juror was somehow prejudiced?
So that's interesting because Pratt's a civil case, right? And so there's minority and majority jurors, and we talk about it in Pratt. Here, one's enough. So it doesn't matter if it goes back to the jurors.
Right.
Counsel, let me try to put a fine point on this. And I'm starting from the proposition that jurors are instructed not to discuss what's happening in the case with anyone outside of the jurors, correct? Okay, so that's sort of the overriding principle here.
Correct.
And so we have an allegation here that this juror discussed the case with someone during deliberations who was not a juror. Is that sufficient on its face to establish the ability to have a hearing to determine whether or not there was indeed outside influence? It may be the father said nothing, although disgust would suggest otherwise, but is that enough to allege that a juror broke the rule that you are not to discuss what's happening during this trial with anyone outside of the jury?
And did that misconduct cause prejudice? Because even if she committed that misconduct, it doesn't matter if she's not prejudiced by it.
And when do you determine prejudice?
Yeah.
So my reading of
Answer all those questions at once.
great. We'll just walk through the post-trial phase. My reading of Pratt is this: when there is sufficient evidence to raise a judicial question, the trial court has a duty to investigate. Maybe that's a hearing. And look, Justice Saylor says the procedure for doing this is up to trial court, so maybe the judge can just do an in-camera inspection. Maybe there's all sorts of tools that the judge can use to inquire here. But the sufficient evidence of potential misconduct that is potentially prejudicial creates a duty to investigate on the trial court's part. And once that investigation goes on, that investigation is subject to abuse of discretion. Once you've had your factual development, however you get there, that's when you apply Carter. That's when you say, oh, now that this allegation was raised and we've looked into it, is this likely to objectively likely to bias somebody? And look, I said at the post-sentence motion hearing, maybe we have the hearing and father comes in and says, well, we just never had that conversation. This is just some guy on the street saying it's completely false. And then I call the other guy and he says, no, he told me. The trial judge makes a credibility determination, and then wherever that goes, I go.
So, Mr. Woods, what you're saying is if we were to follow your recommendation as articulated by Justice Donahue, that any time an individual sitting in the jury, but hypothetically a defendant family member sits in, watches the trial, verdict comes back guilty, we're now permitting someone to make an allegation, oh, I watched juror number 4 and 5 talk, or I heard them say, or I seen her at lunch, and that now gives us carte blanche to hold an evidentiary hearing over each and every allegation based upon hearsay.
No, I'm saying when there is sufficient evidence that there is external influence. Legally sufficient evidence.
So are you sharing with us that from the affidavit, that particular, I have the affidavit, let me see which vermin it was.
It's paragraphs 11 and 12.
Are you saying that that is sufficient, that I had the conversation and that we prayed on it, is sufficient evidence of undue influence or prejudice?
I would go broader than that. I would say that we're let me just get the language right. We talked about how she was a juror. Maybe that's fine. What was happening during the trial? We talked about what was happening during the trial.
Is that a crime since these are open criminal or prejudicial or influential when every criminal courtroom in the Commonwealth is open to the public?
It's not a crime, but if we went downstairs and someone was talking to a juror about what was happening at the trial, I think the trial court jumps in and says, hey.
That's my question. What would have happened if this came up during trial?
Oh, exactly.
What happened if this allegation was put forth before the jury verdict was rendered,
Right.
brought to the trial judge's attention that juror A was seen in the hallway talking with her father about the case.
Right. I think.
What would happen?
You'd colloquy them.
Well, you have a colloquy.
The jury call-
You'd have
A colloquy.
a-
Correct. You would
investigate
colloquy the
further.
witness, you'd bring the witness in, you'd ask about who they were speaking to, what the content of the speaking, whether or not they received any information that might adversely affect or impact.
Exactly.
And then you would ask them whether or not they imparted that information to the other jurors.
Right. And then you would make a credibility determination.
And remove them and replace them with with
The alternative.
That's different,
The point of this,
completely
the point
different
of
than
this
this.
then is that the denial in such circumstances of any inquiry or hearing on that alleged contact would be error.
Right, and you can call it an error of law if you use a sufficiency construct. You can call it manifestly unreasonable because it's clear that someone has an obligation to investigate under these circumstances. But at the end of the day, there's a judicial question about whether there's a 13th juror in this case, and I just don't know any basis that we can say it's okay to not inquire about that.
Right,
argument.
and just to be clear, you're not asking for us to reverse a murder conviction. You're
No.
asking for an evidentiary hearing.
Right. And look, that's what I thought would happen. I thought we would get a hearing. And there's one more point that I want to just get out there. Part of this is you have the hearing now. You have it when it happens so that you get the evidence right away. So this was 4 years ago. Now the witnesses are not, their memory's not so good. Who knows who's talking in the community? We have, in this case, and this is not Mr. Bible or Mr. Thank you, Mr. Dreyer.
Father-in-law is no longer the father-in-law.
Right, but we had the predecessor district attorney go out and interview Dad, unbeknownst to me, while they're saying, "Hey, you can't go do this in court." So that's going. So now are we calling the former DA to talk about what Dad said during? There's stuff there. We have one of the potential witnesses from the other claim somehow got the trial judge's cellular phone number and is sending him text messages that he's disclosed. So, and I'm not saying this is not about that, but this is about it's important to deal with this right away, just like you would if they were in the hall, because that's when the evidence is most reliable and it can be managed, and we cannot have conversations about, oh, well, what did juror X or Y say in the jury room? We can have conversations, well, what did you say to your dad and what did your dad say to you? And we're done. That's what this is about. And it's about protecting the court. It's interesting. I think there's an attitude that what I'm doing here is I'm saying, hey, impeach this jury verdict. We're trying to mess things up here. But what I'm saying is the trial court had an obligation to investigate here to protect the jury verdict. The trial court's investigation here would police that boundary and manage this case. By not doing that, we're 4 years down the road. Who knows what this hearing is going to look like now?
All right, it's really an interesting case. It was well argued by both sides, and we appreciate it. Thank you both.
Thank you, Your Honor.
Thank you.
Call the next case, Mr. Minner.
Mary Jo Gidor versus Benjamin Mangus, representing Mrs. Gidor, Mr. Philip C. Hall, representing Mr. Mangus, Mr. Arthur Mangus.
Yeah, no, thank you. I got enough.
All righty. In this appeal by allowance, appellant hired appellee to perform a home inspection. The home inspection report was delivered to her in June 2017 and disclosed no structural defects. Relying upon the home inspection report, appellant purchased the home, During the following winter, she discovered the home had no foundation and was supported by wooden posts. This sounds like a good bar exam question. In August 2019, more than 2 years after the home inspection had been delivered, the report had been delivered, appellant filed an action against Aplt, raising contract and other claims. Aplt responded by filing a motion for judgment on the pleadings, contending that appellant's action was time-barred under Section 7512 of the Home Inspection Law, which states that an action to recover damages arising from a home inspection report must be commenced within 1 year after the date the report is delivered. The trial court denied appellant's motion for judgment on the pleadings, finding Section 7512 to be ambiguous and construing it as a statute of limitations subject to equitable tolling. However, the Superior Court reversed. The court held that Section 7512 was unambiguously a statute of repose, and that appellant failed to file her action within 1 year of when appellee delivered the home inspection report. We granted L.K.C. to examine the issue of whether Section 7512 constitutes a statute of repose which barred all claims raised in appellant's complaint or a statute of limitations. Please proceed.
Thank you, Madam Chief Justice, and may it please the court. My name is Philip Seaver Hall, and on behalf of the Knox Law Firm, I have the great privilege today of representing Dr. Mary Joan Gidor. This court should reverse the Superior Court, remand the case, and hold that Section 7512 of Pennsylvania's home inspection law is a statute of limitations, not a statute of repose. The differences between statutes of limitation and statutes of repose have been well settled in this Commonwealth for nearly 2 centuries. And against that robust legal backdrop, the General Assembly made a deliberate choice to label Section 7512 a statute of limitations and put the key textual hallmarks of such a statute into the law's operative language.
You say it's been clearly established for, hundreds of years, but unfortunately, we're still arguing about it, right?
Well, there's definitely truth to that, Madam Chief Justice. The lines are not always so distinct, and the purposes underlying statutes of limitation and statutes of repose often overlap, right? Like statutes of limitation also grant repose to defendants, and so there is significant overlap. Nevertheless, this court made clear in Dubose versus Quinlan on page 647 of its opinion that the words "must be commenced" are some of the biggest hallmarks of a statute of limitations. The General Assembly, drafted it with precisely such language. It drafted Section 7512 with those exact words: "must be commenced within 1 year."
How about the language from Dubose that says the statute of repose bars any suit brought after a specified time since the defendant acted?
Yes, Justice Donahue. So on page 15 or 16 of our brief, I don't remember exactly which one, we make clear that it's not always so clear under the text of 7512 whether the home inspector will always be the defendant. For example, it's not hard to understand, it's not hard to ascertain a hypothetical, for example, where the home inspector is the plaintiff suing the consumer for breach of contract for delivering a home inspection report, but then the consumer skips out on the home inspector's bill. Under the plain text of Section 7512, that is an action to recover damages arising from a home inspection report, and therefore it would fall squarely within Section 7512's language. And so applying that reasoning from Dubose, it is not clear under the text of this law that the home inspector will always be the defendant. It happens to be so in this case, but engaging in statutory construction, that is hardly preordained.
Well, but that's true under the language that deals with construction claims. I mean, the contractor sues because his bill wasn't paid. I mean, like, we clearly indicate
if I can,
upon the conduct of the defendant when the action of the defendant took place.
if I can very respectfully push back on that just a little bit, Justice Donahue, there is materially different language between Section 5536 and Section 7512. Section 5536 includes the following phrase: a civil action or proceeding brought against any person lawfully performing, furnishing the design, etc., of or observation of construction. That key phrase, brought against a construction worker, makes clear, unlike Section 7512, that the construction worker is the defendant under Section 5536. Here we don't have that. And so I don't think there's any textual basis to
How about a builder who sues the architect?
I'm sorry, can you?
How about a builder who sues the architect?
Well, I mean,
The builder could be a plaintiff, the architect is the defendant. I mean, and I don't think, maybe the one you're saying proposed applies or not. I don't know, but clearly 5536, which has the same potential dichotomy, has been construed to be statute of repose. I just don't know how you get around the language from Bow that says the hallmark of a statute of repose is that the time frame is, specified time is based upon the defendant's action.
I think the way we get around that, Justice Donahue, is from Dubose itself on page 647, where the court said that the phrase "must be commenced" is the key hallmark of a statute of limitations.
But that's the same language that's used in 5536.
Right, and I obviously don't want to, argue in circles, but, I think that there is a key textual distinction here between 5536 and 7512, in that 5536 is markedly more specific about which party's which. And here we don't have that. And so I think, at the very least, if the legislature didn't speak to it, then it is plausibly ambiguous.
What about the title of the act? The title of the statute? Could you address that?
Absolutely, Madam Chief Justice. So we fully admit that under the title and headings canon, an unambiguous statute, when the court is construing or examining an unambiguous statute, it can't consider the title and headings to create ambiguity. That's not what we're doing. Instead, we think that the operative text of Section 7512 is plausibly ambiguous, as the trial court held. Once you reach that conclusion, the next step, obviously, is to apply the canons of construction. And then you can turn to the title and headings, which I think, what better, example of what the legislature was thinking than the actual label they put on their own law.
Which is? Let him just finish this. The title on this act is statute of limitation.
Yes, Madam Chief Justice, that's correct.
Let me follow up on your statutory construction point. In 2019, the General Assembly attempted to amend 7512 to make it a statute of repose specifically, and that was vetoed by Governor Wolf. Is that correct?
That's correct, Justice
What, if any,
McCaffrey.
what, if anything, are we to take of that particular action?
So, being as forthright as I can with the court, there is case law out there, quoting Justice Scalia, that talks about how subsequent legislative history is somewhat of a misnomer, and that there's little, persuasive weight that the court should put on subsequent legislative history. And we fully concede, we concede that that's out there. But I think, if anything, if you are going to examine that, what you should take from it is that the legislature identified, hey, this is at best ambiguous, at worst it's a statute of limitations, and that's not what we want. And so we need to effect a change. And by specifying that added language, and for the record, under the proposed language that the General Assembly added in 2019, I think there's no question that would have been a statute of repose.
Right.
But again, here, we don't have anything like that.
Does that attempt manifest their intent that it is a statute of limitations as written?
Does the 2019 amendment?
The attempted amendment that was vetoed by Governor Wolf, in your mind, does that manifest an intention or an admission by the General Assembly that it was in fact a statute of limitations that they were trying to change into a statute of repose?
I think that's a fair conclusion, Justice McCaffrey, yes. At the very least, even if you're not persuaded about that, the General Assembly made clear that, hey, there's some ambiguity here that we need to clear up. And so for that reason, I think Section 7512 is facially ambiguous, requiring the court to resort to the canons of statutory construction to resolve the ambiguity. One key canon, I think, here is that Section 7512, or excuse me, the home inspection law generally is a remedial statute. And this court has made clear that remedial statutes must be liberally construed to effectuate their remedial purposes. Here, the home inspection law has a section setting forth the duty of care, saying that home inspectors must act as reasonably prudent home inspectors would. It includes a section titled Consumer Remedies, where it sets forth various consumer remedies in the event of a breach. And also it requires that home inspectors carry insurance for at least 1 year, thereby manifesting the General Assembly's intent to ensure that consumers are adequately compensated in the event of a breach. And I think,
For at least 1 year.
well, I think that,
Why would they mention any time frame at all? I mean, I see at least 1 year, and that's just to effectuate notice provisions under an insurance policy or something of that nature. Why mention a time frame at all?
I think the reason for including the time frame, Justice Donahue, is again to ensure that consumers are fairly compensated. Here,
At least a year.
right, exactly, and that
They are under a statute of repose, right?
well, that language though, at least 1 year, is the key language here, I think, because if Mr. Mangus is correct that all liability is cut off after a year and a day. There's no liability that can exist after that. All claims have been substantively extinguished. Then those words, at least 1 year, become mere surplusage. And this court has also made clear that that's not how we read statutes either. And so I think in order to give effect to those words, at least 1 year, you have to read Section 7512 as a statute of limitations to which the discovery rule can plausibly apply.
Do we know from the record how much your client paid for this home inspection?
We don't know from the record how much she paid for the home inspection, Your Honor. The home itself was over 90.
I'm interested in what the cost was for the home inspection and the subsequent report. Because what you're arguing essentially is that this home inspector is going to be the insurer of that home for an indeterminate amount of time. Your client discovers a structural defect 20 years after purchase. Home inspector who got $495 to do the home inspection is now the insurer of that home for that structural defect.
So if I can just respectfully push back on that, Justice Donahue, our position is not that home inspectors are indefinite guarantors of a home's condition. I think Mr. Mangus endeavors very hard to
I don't know how you can look at it otherwise. You're suing the home inspector for the damages incurred because of the home inspector's failure to identify a structural defect.
But it's not a strict liability statute.
precisely, Madam Chief Justice.
You're suing them. So, yeah.
That's correct. We are suing them. And all we're saying is that, hey, just what the statute says in the home inspection law, it says, if you're going to get into this business, you have to exercise reasonable care. And that's all we're saying, too.
But you are saying, following up on Justice Donahue's question, that for an indeterminate number of years, you can be sued for negligence.
Sure.
In that limited set of circumstances, Madam Chief Justice, where there's a hidden defect that is readily ascertainable to a professional, but not a layperson, and I think this is a unique set of circumstances in that way. But in this unique set of circumstances, yes, the discovery rule can provide for such a suit as it can in many other types of cases.
Yeah, but in those circumstances you're talking about, would have to be you'd have to engage in discovery to see whether or not it would in fact be covered. Or in other words, it was in fact readily discoverable at the time of the home inspection.
That's precisely correct, Your Honor.
We're not talking about strict liability. You still have all the elements of proof either on a breach of contract for 4 years or a negligence claim for 2 years if it was a statute of limitations, right?
Correct, Justice McCaffrey, yes. And again, this is a pure question of law, whether the discovery rule can plausibly apply to Section 7512. Not necessarily whether it does apply in this case. That's an issue for summary judgment.
It's not forever, right? If we determine this is a statute of limitations, not a statute of repose, and therefore it's subject to the discovery rule, is it forever? That is the liability, the risk of liability? Is it forever?
Oh, I think not, Madam Chief Justice. No, because the case law is clear that you have to exercise reasonable diligence to discover injuries, right? If you ignore something, for example.
But let's assume that
They did.
Let's assume that they didn't ignore anything. But 25 years after the home inspection, a structural defect evidenced itself. They get 2 years from that 25-year period, but that's 27 years after the home inspection.
Yeah.
Correct?
Correct.
Or 30 years plus 2 years.
Correct, Justice Donahue. As long as, and I think this is important, as long as that structural defect was readily ascertainable at the time of the inspection itself. Again, we're not saying that home inspectors should have to divine likely issues with a property. That's not necessarily the issue. They're not indefinite guarantors of the property. We're just saying, hey.
Well, they're not guarantors at all because it's a negligence stand.
Precisely, Madam Chief Justice, yes. All we're saying here is that, hey, you should have found out, you should have taken a look under the addition and saw that it was supported only by 4-inch by 4-inch wooden posts without a foundation. We don't think that's asking too much of a home inspector. Turning to the constitutional doubt issue, because I think this is critical, especially, Justice Donahue, under Yanakos. That I think is a key issue here. Under the constitutional doubt canon.
Let me ask you a question.
Of course.
If you're going to make an argument like that, and this isn't the only case this comes up in, do you have to put the Attorney General on notice that you're calling into question the constitutionality of this statute?
No, Justice Donahue, because this court has made clear in the past that notice to the Attorney General is only required in facial attacks on a statute's constitutionality. And Justice Brobson, as you said, in Zimmerman versus Schmidt, in your concurrence, that makes good sense because the reason for the notice rules is to ensure that statutes are only struck down on their merits rather than on procedural technicalities like a default judgment. And that's not what we have here, so those policy rationales don't apply. Instead, we're actually asking the court to avoid having to strike down this statute.
Because it could be unconstitutional. So we have to go through the entire analysis, determine whether it could be unconstitutional, and then say, we're going to avoid this question because it could be unconstitutional.
I think that's right, and that's exactly what the court in Herald versus University of Pittsburgh did just a few months ago.
I said it's not the first time it's come up.
Right. And the issue is not that we have to clearly, palpably demonstrate that this is violative of the remedies clause. Instead, all we have to do is show that it raises serious constitutional doubts. And on that score, Mr. Mangus at no point in this case has ever contested that proposition. He could have, for example, cited a study showing that home inspectors are subject to abnormally, high insurance rates or something like that. The typical justification for a statute of repose under the remedies clause. He hasn't done that. And so there's no basis to conclude here that Mr. Mangus could satisfy intermediate scrutiny, assuming that we're right and this is a statute of limitations. And again, all we're asking is for this court to do exactly what it did several months ago in January in the Herald versus University of Pittsburgh case.
And I don't know the answer to this. Was 5536 ever challenged as being unconstitutional because of the conclusion that it's a statute of repose?
I don't know the answer to that, Justice Donahue, admittedly. But yeah, so the home inspection law, as I was saying, is a remedial statute that must be liberally construed. And I think also it's important to take into account the absurdity canon here. That's a well-established canon of construction. And here, the upshot of Mr. Mangus's argument and the Superior Court's conclusion is that consumers can no longer rely on their home inspector's expertise, that they have to effectively hire additional home inspectors to fact-check the findings of those that came before. I think as a common sense matter, That cannot be right. That cannot be what the General Assembly had in mind. It just can't. And so for that reason, I think the court should also turn to the absurdity canon when construing this statute to avoid that unnecessarily absurd result. Turning to the preemption issue that Mr. Mangus has raised throughout this case, there have been at least 3 separate justifications for that conclusion. I think none of them are applicable here. The first one that he raises is the statutory exclusivity rule, Section 1504 of the Statutory Construction Act. And here, in the section entitled Consumer Remedies, Section 7505D of the Home Inspection Law, the legislature actually made clear that it desires to expressly preserve all remedies available, quote, under the UTPCPL or other applicable provisions of law. And so I think there's just no basis here to conclude that the legislature somehow impliedly abrogated the common law when in fact they expressly rejected that presumption. Secondly, the legislative preemption issue that the Superior Court raised, I think, is similarly inapt, because the Superior Court cited Nutter versus Doherty, a case that discussed legislative preemption. And preemption is not applicable here because there's no municipal ordinance that's being compared to a state statute to compare which should prevail. There's no express preemption, there's no field preemption, and there's no conflict preemption. And therefore, there's no basis to conclude that the legislature somehow impliedly abrogated the common law on that ground either. And in fact, in Roverano versus John Crane Incorporated, a 2020 case from this court rejected that precise argument that Mr. Mangus is making here and that the Superior Court made below, that because the statute is somewhat comprehensive, that impliedly indicates the legislature's unstated intent to abrogate the common law. The court in Roverano said, yeah, we don't construe statutes that way. The legislature has to expressly preempt common law in order for the common law to be disregarded. If the court has any further questions, I welcome them. Otherwise, I will step down.
Mr. Severhall, is this your first appearance before this court?
It is, Madam Chief Justice, yes.
And how long have you been practicing?
I have been practicing for 4 years now.
Well, welcome to the court. Very well done. Thank you.
Thank you all very much.
Hear from Mr. Martinucci.
Your Honor.
Your opponent set a really high bar, so you better be good.
Even worse, we're from the same town, so I have to see him all the time, right?
Oh, no.
Through the snowdrift.
We do have those. We don't live close enough that I can snow blow to his house, but. Madam Chief Justice, Justices of this honorable court, my name is Arthur Martinucci, and I'm the attorney for Benjamin Mangus in this case. An action to recover damages arising from a home inspection report must be commenced within 1 year after the date the report is delivered.
And that's by virtue of a statute of repose.
This is the language of the statute.
Yeah, but I mean, well, the reason I'm asking you is I'm curious if you found any other 1-year statute of repose in Pennsylvania law.
No, sir.
I mean, what is it that's so, special about home inspections that would require the strictest standard of repose? I'm talking about standard of
Yes, sir.
statute of repose in Pennsylvania. Out of all the things in life, why would a 1-year statute of repose exist only for home inspection?
And despite the title, that it's a statute of limitation.
Right. So, Justice Doherty, I have to confess to eavesdropping there a little bit, and I agree with you, because the General Assembly said it so, right? I can't get into their heads and tell you why they chose this. I can surmise, and I can surmise because if you're going to pay somebody $500 to come and take a look at your house for an hour,
and then you're going to pay several $100,000 for that house, that individual that you paid $500 to should not be on the hook for an extended and potentially unlimited, certainly indeterminate period of time in exchange for that $500.
Yeah, but they're not on the hook. It's their insurance company. Not that we're supposed to know anything about that, but
In theory, you're right. But by the same token, sir, there are instances where insurance companies deny coverage. Okay? And maybe it's a contractual basis. Maybe it's because the home inspector has stopped and a year has passed and he doesn't carry that insurance anymore. And they say, well, this is, this isn't a policy that we're going to honor at this point in time because you did this inspection 2 years ago and the insurance stopped. Now you're not doing these anymore, so the insurance stopped and the claim wasn't made within the time applicable to the policy.
that's under a claims-made policy, but there's different policies you could acquire that would cover you for any damages relating to a negligent home inspection, for instance.
I think that theoretically that is possible, but whether or not that is the case here is something that's not a matter of record and not relevant.
Well, not that any of this is a matter of record, but the insurance premium is likely based upon the period of exposure.
I would agree, absolutely. And if the exposure is unlimited or the exposure is indeterminate, then the cost of that is going to go up, and then the cost of the home inspection is going to go up. Or if this court were to determine that this is a statute of limitations and not a statute of repose, then at that point in time, parade of horribles, but at that point in time, you have a situation where insurance policies might just start going by the wayside, right? Where an insurance company says, we're no longer writing this, we're not going to renew you.
Let me ask you another question. It's a more practical question.
Yes, sir.
Everybody, I think, understands here, you acquire a home, you retain a home inspector to do a home inspection, so you don't buy a house that has a lot of damage to it. I mean, that's what you want to obtain an expert to take a look at it, make sure everything's okay, so you don't have to have expenditures out of your pocket. It's almost always done in contemplation of an agreement of sale and closing on a property, right?
Yes, sir.
If we adopt what you're saying and say this is the statute of repose, which is 1 year from the date of delivery, what happens if my closing is delayed or I choose not to move into the property for a year or a year and a half? I mean, basically, you're saying that in that situation, I'm completely out of luck.
But you're on notice, right? That you've got 1 year from the date that the report is delivered. It is clear. So you can make adjustments at that point in time.
What adjustments could I make if for whatever reason the seller can't contemplate or close on the deal, or my financing doesn't come through for 6 months or a year?
Pay another home inspector $500 to go out and take another look or give you a new report, okay? Possibly bring suit against the home seller for failing to disclose defects, or against the realtor for failing to disclose defects that should have been discovered.
You're assuming there are defects. I'm not. I'm just basically saying we accept that it's a statute of repose and I don't close on the property, but they give me the report for a year before, I can't sue the home inspector if I get in there on day one I discover significant problems with the property that he should have picked up on.
I recognize the hypothetical. It is within the realm of possibility, but not the realm of probability, okay? In that instance, yes, you would be out of luck at that point in time because that's the nature of a statute of repose.
Does the 1 year period call into question the constitutionality of this statute of repose, if it is such a thing?
Well, first of all, I believe that any constitutional arguments have been waived because the Attorney General was not put on notice. I'm sorry.
I think he's correct about the putting on notice. This is not a direct challenge.
I believe this is
challenge.
If you look at the relief, I believe respectfully that it would be a facial challenge, because you're saying that it would be unconstitutional as to the entire class of homeowners. It's not an as-applied challenge.
He's saying he's not really challenging the constitutionality. He's saying, take a look at this and analyze it, and you may conclude that this could be unconstitutional, therefore call it a statute of limitations.
Okay. I think that at the end of the day, the nature of the challenge would be facial. However, looking at that situation, and your analysis of it, I do not believe that the fact that it is a 1-year statute of repose poses any constitutional question.
Mr. Martinucci, could you address the title of the statute?
The title of the statute is irrelevant.
Well, no, but let's just acknowledge.
It says statute of limitation, just like the title of the statute in Dubose said statute of repose, but you looked at the language of the statute itself and determined in that instance that that was a statute of limitations, despite its title.
If it's clear, right, are we looking at whether it's clear to us that it's one or the other, or do you just say we don't look at the title at all?
Oh, I think that you look at the language, and if the language is clear and unambiguous, you follow the language, and the title is not an issue. If you look at the trial court's opinion in this matter, the trial court went right for the title. There was no analysis. He said, oh, they wouldn't have called it a statute of limitations if they meant it to be a statute of repose. Therefore, I find it to be ambiguous. That's his analysis.
But you don't get to the title unless the language of the statute is ambiguous.
Exactly. And again, you've got 24 words here, one sentence. This is about as clear a statutory directive as you can get in this Commonwealth with the General Assembly. And there's no ambiguity in any of this language.
Well, your opposing counsel says, I don't know if this is an ambiguity or just a potential outcome of this, that this could mean that the home inspector would have a year to sue the homeowner for, he says, damages arising from a home inspection report. I'm assuming he's saying for not paying for a home inspection, not for the report, but I mean, help me with that.
And that is, I believe, his argument. So in that regard, the first thing that somebody would have to do is determine whether or not the issuance of an invoice arises out of a home inspection report. If it does, then yes, the 1-year statute of repose applies. But what is important is the date that the clock starts ticking. It's the date that the report is delivered. And if that's the case, and if the home inspector has to live with that, then so be it.
Counsel, could you distinguish this statute 7512 from section 5536?
Honestly, Your Honor, I could not. I believe that they are essentially the same language. There's a little bit more in play there, but the must commence within a period of time language is identical, and this court has repeatedly held that to be a statute of repose and has applied it. Now again, you might have an issue with the General Assembly's assignment of a 12-month period of time as opposed to a 12-year period of time.
But let's talk about that for a little bit, because if this violates the remedies clause, then the legislature needs strong reasons, strong government interests for imposing a 1-year statute. What would those strong reasons be?
Well, I think that they would take a look, and again, I'm putting myself in the place of the General Assembly, so hopefully they'll follow this argument and listen if they need to do something. But at the end of the day, I think that they would look at the entire home buying process, because getting a home inspection report isn't just a matter of convenience, and it's not just a matter of wanting to make sure that you get a home without a lot of defects in it. It goes to financing, it goes to the mortgage process, it goes to the insurance process, okay? All of these things are important. And if you pull the plug on this and all of a sudden getting a home inspection becomes more expensive or finding a home inspector becomes more difficult, then you're going to slow that entire chain of commerce down. And I think that my opposing counsel indicated that there were approximately 134,000 homes, maybe even more than that. I should forget if it was 134 or 189,000 homes purchased in the Commonwealth of Pennsylvania. So you're going to put a plug in that.
Or maybe you're going to make home inspectors more careful. Is that possible?
again, without suggesting that my client did anything wrong in this case, again, that is within the realm of probability, of possibility, but is it within the realm of probability? I don't know. I don't think so.
Well, okay.
A home inspector could exclude an inspection for structural damage, could they not? I mean, because that's really what the problem is. I mean, if there's a, electrical box defect or, a significant plumbing issue or something of that nature, that's going to show up.
But a lack of foundation seems pretty foundational.
But could a home inspector exclude an inspection for structural sufficiency or structural integrity from the home inspection report?
I would need to take a look at the statute itself, because I think that there are specific things that are required and specific things that are excluded.
That's not statutorily driven, that's contractual. Because the contract between the homeowner, the prospective homeowner, and the home inspector always excludes certain items that are not visual. For instance, termite damage on a hardwood floor where there's carpets down, that's almost always excluded.
But I think that some of that is addressed in the statute itself. Some of that is addressed in the statute itself, so I think that it is statutorily driven.
Okay.
So, yes, theoretically they could, but could they do it without additional legislative action? I don't know. I'd have to look at that to tell you.
Okay, I think we understand the case. Is there anything else you want to say to us? You feel compelled to say?
No, Your Honor, I appreciate the opportunity to be here today, and I do hope that you will look at this, look at the briefs, and agree that this is in fact a statute of repose.
I promise you we will look at this and look at the briefs, and no promises as to the outcome.
And you did an equally fine job.
Yes, you
Thank you, Your Honor, I appreciate
I'm not going to
that.
ask
Each other
how
on
many
the
years
street.
you've been out of law school, provided you don't ask me.
I will not ask you. I will tell you that I'm in my 34th year, but this is the first time that I've been in front of this court.
Well, welcome.
Thank you.
Congratulations.
So when you
Thank
see
you
him, when you
both
see him on the street of your hometown, you can hold your head up high, all right?
Oh, absolutely.
Well done.
All right, Mr. Minner, I think we will take a brief lunch recess, and the court will return at 12:45.
Court is in recess until 12:45.
case.
T.M.H. Jr. versus J.L. and K.L. Appellants versus L.K.C. Representing appellants, Ms. Gail Calderwood. Representing L.K.C., Mrs. Carrie Despoy.
In this child custody matter, the child's parents entered into a consent agreement granting paternal grandparents shared physical and legal custody of the child. Tragically, thereafter, the child's mother committed suicide. Maternal grandparents then filed a complaint for modification of custody, seeking primary physical custody and legal custody of their grandchild. Paternal grandparents responded that the maternal grandparents lacked standing to do so, asserting that they failed to file their complaint within 6 months of the date the child last resided with them, as required under Section 5324 of the Child Custody Act. Finding that maternal grandparents demonstrated standing under Section 5324, the trial court awarded maternal grandparents primary physical custody and shared legal custody of the child, and also awarded partial custody to the child's father and paternal grandparents. Paternal grandparents appealed, reiterating the claim that maternal grandparents lack standing to file their action. The Superior Court agreed and reversed the trial court's ruling under Section 5324. In this appeal by allowance, we examine the propriety of the Superior Court's ruling. Please proceed.
Good afternoon, Chief Justice Todd and the esteemed justices of the Supreme Court. My name is Gail Calderwood. I represent the appellants, the maternal grandparents, and I will refer to them as maternal grandparents throughout my argument, if the court would permit. I'll refer to their grandchild as child. And for the appellees, it is essentially maternal grandmother that is fighting this case, so I will refer to her as maternal grandmother. The maternal grandfather is a step-grandparent, and he was, as I think the trial court described, a quasi-applicant, or the Superior Court described him that way. He wasn't that involved.
He's no longer participating in the appeal, anyway.
That's the father, but the step-grandfather just never really...
The grandfather.
Yeah, he doesn't really seem to play a big role, let's put it that way, in this. And I don't think he technically filed to intervene. It was the paternal grandmother. Okay. So it gets a little confusing because sometimes the record refers to paternal grandparents, but it's really paternal grandmother.
All right.
So with that out of the way, Your Honor, we're here today because I'm arguing that the Superior Court committed an error when it ruled that essentially, as long as father is alive and hands the reins of parenthood to his parents and his mother, the paternal grandmother, then the maternal grandparents cannot assert that the child is in a state of neglect or substantial risk, and they are barred from proceeding under the subprong B of 5324, paragraph 3, subsection 3 III B.
That was never raised in any pleading, in any hearing, and I'm not aware of how an appellant can change a standing section sua sponte.
Now, I understand, Your Honor. At the trial level, the counsel for the maternal grandparents filed initially a petition to intervene and subsequently followed that up with a custody complaint. Neither one of them specifically raised subsection B or correct. And at various times throughout the litigation, there was discussion about whether they might have in loco parentis status, which they did assert at one point. They also at one point argued they might qualify under subsection C, the 12-month, 6-month rule, as I like to call it. But they also generically did argue that they had standing under 5324 on the record in both testimony, and then the trial judge, when he ruled on the matter, granted it was a very succinct ruling, but he stated that he felt they had standing under 5324 subsection 3. He did not go into any great specifics at that time about how he reached that conclusion. But our argument is that on appeal, on this de novo appeal, the review of the Superior Court should be to also consider all applicable law, and they overlooked...
Yeah, I'm sorry, but I think that's another sort of disjunction here. I know that the trial court can raise standing
Well, I think the standing was in front of the appellate court under 5324, and they were considering A, B, and C in their opinion. They rather quickly threw out A, that did not apply, and they rather succinctly disregarded B because, again, they felt that this cloak of safety put that claim off limits, and therefore the maternal grandparents were barred and constrained from proceeding under that prong. But the Superior Court themselves considered all three prongs. But in their effort to do so, the majority opinion overlooked the findings that their own court had made in the Gap case previously, and it was in Judge Bowe's dissent that she argued that that should have been a consideration, that the court should have considered all applicable law. And so we're just arguing that it falls under the grand umbrella of that 5324 standing argument, and that under Gap, it was explicitly this kind of situation that the Superior Court was saying should not allow one set of grandparents to gain a foothold and shut the door essentially on the other grandparents. And in that case, the maternal great-grandparents had custody, and they were opposing an award of standing to the other set of grandparents. And the child at that time, they argued, could not be substantially at risk because they were involved and they were taking care of him, and their benign presence protected the child. But the Superior Court ruled that that was not sufficient. If both parents are unavailable and or unwilling to care for a child, and that child is therefore left at risk and in a state of neglect, then the standing can attach for both sets of grandparents. And that's all we're arguing today, is that our clients should have been allowed to proceed with standing under the Gap ruling and under subprong B of 5324.
Counselor,
Yes.
as we stand here today, who has custody of the child?
My clients have custody of the child, Your Honor. The maternal grandparents still have
How long have they
custody.
had custody of the child?
I'm sorry?
How long?
Well, they've had custody since 2021, and the child has had no contact with the paternal grandmother for 3 years and refuses to talk to her at this point. Unfortunately,
Why does she refuse to talk to her? Why has she had no contact for 3 years?
the child himself is refusing the contact, Your Honor, and when they have tried to make him go, he has threatened to commit suicide.
How old is the child now?
He turned 15 in January. He is in therapy and he takes medication and he's doing very well in school now, but he does not want a relationship with the paternal grandmother at this point. And part of the problem is all of this litigation and everything that has happened has helped to traumatize this child, and our clients have been trying to get him all the help that they can. And I would note, I know we're not supposed to argue the facts too much, but during the trial, paternal grandmother at one point indicated she didn't believe in therapy. And she actually discontinued his medication when he was in her care. So again, the trial judge is aware of all these facts. The new trial judge that they have now, because the old prior special judge that was appointed retired, he has continued on with the case and allowed my clients to keep custody. And there's an ongoing standing argument in front of the trial court right now that went up on appeal and was quashed. The paternal grandmother has now filed 3 appeals in this case, Your Honors. So going back to my argument, if I could, I would just like to note that it is undisputed in this case that father is an uninvolved parent. I mean, he's been described as apathetic, he's been described as exhibiting parental detachment from the child. He barely participated in the proceedings, and on questioning on the record, he stated he didn't really know if he wanted to exercise custody of his child.
Does he see the child?
As far as I know, he hasn't seen him in the 3 years, as far as I know, Your Honor. And prior to that, it was extremely sporadic. And there was a period of time during the litigation where I understand he barely spent any time with him. That might be disputed by the other side. But I would say that father has both stated on the record and exhibited through his behavior a complete lack of willingness to act as a parent to this child. And it was parental grandmother who tried to step in and take on that role for him. But then she claimed that precluded my clients from playing a role in the child's life, even though the child had lived with them since he was a baby. And go ahead.
Despite pending these appeals, has paternal grandmother filed a petition under 5325 grandparent statute?
Paternal grandmother?
You're saying your client's mom's mom,
Correct.
she's in custody.
Correct.
Dad's mom has filed 3 appeals. The question is, does this record also consist of while those appeals appeals were pending, grandmother, father's mother sought some type of partial physical custody pursuant to the grandparent statute 5325?
Don't want to speak out of turn, and I wasn't the trial attorney, but I am not aware that she filed under 5325, but I will let my
We'll get
esteemed
there.
counsel speak to that. Right. I'm sorry I can't answer your question fully, but
So the issue right before this court is that you lack standing, that the child should be removed from you and given to paternal despite 3 years and 3 appeals.
that's exactly what would happen, Your Honor. And not only that, but my clients would be stripped of their ability potentially to go back into court and seek shared or primary custody. They would be reduced to only being able to go forward under 5325 ostensibly, depending on how future litigation goes over standing at the trial court level. But, Your Honor, under 5325, a deceased parent doesn't give them the right to have the level of involvement with this child that they've had all these years. And if something happened to paternal grandmother, then my set of grandparents wouldn't be able to step in and say, oh, we should take this child. The child would revert to father, who has no interest in this child and has no real bond or relationship with him. And that is a major concern of my clients, and one of the reasons that they proceeded with this matter. They just want what's best for their grandson.
So share with us, the issue before us is the standing issue.
Exactly. It's limited to just the standing issue, Your Honor. So
Tell us how
very
you have
simple.
standing.
They have standing under the GAP case, Your Honor, and that should have been considered and applied by the Superior Court. Because under the GAP case, the argument is essentially that one set of grandparents cannot create a cloaking protection over this child and therefore bar the other grandparents from coming into court. The intent of the statute is to allow grandparents who have this kind of involvement with the grandchild to come in and potentially play a role and let the trial court decide who should have what type of custody. But to bar them completely and shut the door when under GAP, they have an argument that this child is at risk and is in a state of neglect. Just because paternal grandmother's there doesn't mean he's not at risk.
Did they raise that, again, I mean, I think you may have attempted to answer this, but did they raise that argument before the trial court?
Not specifically, Your Honor, they did not. And I think part of that is as cases develop.
Don't they have to?
Well, I think if you take a very technical interpretation, yes. But I also think standing is fluid, as they stated in the GAP decision. And
Standing is a prerequisite. I mean, technicalities are what we do. I mean, standing is a prerequisite for custody, and there's a good reason for that, right? For parental rights and Troxel versus Granville and everything. The first time your clients raised this subsection was in the Superior Court brief. It wasn't ever raised before. It was you had in loco parentis. There was language at some point earlier that looked a lot like subsection C, different subsection than you're at here. I mean, given they never asserted this standing under this subsection, why isn't it waived? Why are we even here? How can we even entertain this? It can't just be that we just invoke best interest, because if we do that, then the deluge, right? If we can always say just best interest, then there's no bars anywhere.
And that's why I'm not arguing best interest, Your Honor. I'm not. What I'm arguing is that they raised 5324 generically. They also argued a couple specific things at various times during the case as the evidence developed. When they first went into court, it was because mother had committed suicide. They knew father was on the periphery, but their concern at the time was the child being in a state of lacking a parent because mom had committed suicide and dad was relatively uninvolved. But as the case developed and it became paternal grandmother who stepped forward and said, well, wait, I have a custody order, which my clients knew nothing about. I mean, when they first filed, they had no idea there was this consent order because it didn't exist. It was done a month later.
Let's discuss that. But first of all, does father share any type of custody, legal custody? Who has legal custody?
He was granted, both the paternal grandmother and father in the final order of the trial court were granted both some partial custody and some legal custody. Yes, they have both, is my understanding.
As we stand today, does father have shared legal custody?
There have been orders entered since then, Your Honor, but I think he might. I would have to, I'm not the.
Question.
Right. As far as I know, he does still have it. He doesn't exercise it, though. He plays no
Got
role.
it, but under the law, he still has legal custody. So the issue now is if we were hypothetically to side with the paternal grandparent, find that you have no standing, the child would have to be removed from your client and given to father. Because he's the only one standing.
Except father didn't appeal the decision. Father only has partial custody, so he can't go to father as primary. It's paternal grandmother who wants him as primary.
I'm looking from this from a perspective. If your client, if hypothetically you lose your standing position, the child, you no longer have standing to have primary physical custody of the child because it has to revert back to father. You no longer have custody.
But it can't revert back to father, Your Honor. The decision in the underlying court right now is that father only has partial. And he did not appeal his decision. He did not challenge it in any way. He's not a part of this appeal. It's paternal grandmother who's saying, I want primary, and the other maternal grandparents should be barred from proceeding for any kind of share to primary. She wants them relegated to partial. Father will remain partial, and she will be primary. That is the underlying case.
Or if we were to follow and find you no standing, father and his mother could come in with a modification requesting joint physical and legal custody, and then mother could raise the child and live happily ever after without your grandparents' participation unless you file under 5325 grandparent statute. Now, I don't know if that would be the best for the child, but I'm trying to take this to the legal logical extreme.
I mean, hypothetically, father could come into court subsequent to this decision and file a modification. He still has not, to my knowledge, filed anything with the trial court. There are activities occurring in the trial court level that I'm not involved in, but I know that there have been modifications filed by my clients. There have been the appeal taken, the quash, there was a rule to show cause, there was a whole bunch of activity. Father took no part in it. It is just grandparent versus grandparent. But hypothetically, yes, Your Honor, that could happen.
Father actually still has partial legal custody, so does he need to be doing anything?
Well, that's the point. He doesn't want to do anything because he has what little he can sort of hang his hat on, but he doesn't exercise what he has. He's father in a custody sense in name only. He's the biological father, and he has it on paper that he has some custody rights, but he doesn't exercise them. And the problem is that is harmful to the child. The child suffers because not only did he lose his mother to suicide, which he's acutely aware of, but his father has zero interest in him and has moved on and had 3 more children with a new woman who he is involved with. And so the psychological effect is something that Judge Bose was highlighting in her dissent, because substantial risk or neglect doesn't just come from physical. It can, as she stated, it can transcend the physical maltreatment. It can be emotional and mental distress.
But that was never raised. By what court order are your clients raising this child and have been for the past
3 years?
3 years.
There was a subsequent court order entered at the trial court level re-granting them primary custody, Your Honor, and also granting them new standing in the case going forward. And that was what was the basis for the paternal grandmother's 3rd appeal, which was quashed because of this appeal. And so we expect...
So why are we here? I mean, there's a court order that superseded the order that we're looking at? Is that what you're saying? And how did that happen?
We're here today because the litigation in this case seems to be never ending. And I think if my clients are denied standing today, what's going to happen is you're going to see a flood of new litigation again in the trial court where paternal grandmother goes in and says, well, I'm going to take this child, I'm going to have primary custody.
We already apparently are having a flood of litigation in the trial court.
Only because this is difficult to say, but I think because paternal grandmother is taking a very technical stance in this case, and all I can say is that if I represented her, I would not be advising this course of action.
If standing's been waived, it's been waived. It doesn't matter if the flood of litigation ensues or the sky falls. I mean, no standing, waiver. It doesn't matter. There are all kinds of sympathetic child custody cases in Pennsylvania, yours isn't the only one.
I understand, Your Honor. But I do reiterate, I don't think they fully waive standing. I think they raise standing under 5324, and that includes all three prongs. And
you just indicated that a subsequent trial judge found standing, and if so,
correct.
when was that, and what date was that order?
Your Honor, I have some of the
Pending-
documents.
Was that prior to the appeal?
I don't know. I mean,
Right, but there was a new order on it. Okay, it says. I'm reading the order for rule to show cause and where it was quashed in the Superior Court. And I apologize, I'm not the attorney of record. That's Todd Spivak.
I don't understand how all these proceedings are going on in the trial court level when this is on appeal on this issue.
I believe they started to proceed again when the paternal grandmother tried to enforce the decision of the Superior Court. She wanted the child to return into her care, and she sent the state police to retrieve the child because he was refusing to go. And the child, my understanding is the child physically broke away from the police, ran away, and then told them he would kill himself if they made him go. So it was a very volatile situation. And grandmother, if I'm not misstating the facts, then brought a petition with the trial court to enforce. My clients filed a modification and to establish new standing, and that started a whole new round of the current ongoing litigation that's in the trial court level.
Why are we what are you asking us to do? I mean, your client has custody under an order that we've never seen.
They do, but I'm not asking you to rule on that order. What's going to happen, though, if they cannot proceed with the standing under 5324, they run the risk that the barn door will be shut in their face.
That issue is apparently,
But it,
again, before, or for the first time, before the trial court.
Or why didn't the trial judge moot the issue if he already ordered standing? I'm confused.
Yeah.
You can't sue for standing when the party has standing given by a judge.
because the Superior Court decision said there was no standing. That was the decision that the clients were operating under.
The Superior Court said that the trial judge's finding of standing was legal error or abuse?
So the court order that was entered in June of 2023 is the one that was reversed by the Superior Court on April 26th of 2024. That's why we're here today. And so paternal grandmother takes the position at the trial level that our clients don't have standing because that was the decision of the Superior Court on appeal to this court. Therefore, because of the time that had gone by and the fact that my clients continued to exercise custody, there's new litigation about whether or not that created a new type of a new standard for standing in the case.
How can that be when the case is pending before us?
I can only tell you that the litigation is ongoing, Your Honor, and that is why it was taken on appeal to the Superior Court, and it was quashed because of this appeal pending. The Superior Court would not rule on it. The trial judge who ruled previously was Clementic. And who's the new one now?
Who's the new one?
Lewis was the last one, Senior Judge Lewis, I believe.
I'm not sure this case is even properly before us at this point. We may have improvidently granted it.
Counsel, let me ask you to recap or tell me if I understand this correctly. The trial court originally, the case that we are looking at, the trial court originally said your clients do not have standing, correct?
No, the trial court granted standing under 5324, 2 and 3.
So
Right.
your clients had standing, and the Superior Court reversed.
Correct. They considered all three prongs. They didn't find prong B was waived. They considered it and said it didn't apply. but they didn't say it was waived. And then they denied standing under 5324 and said it had to be remanded to consider standing only under 5325. And therefore, we filed the appeal because my clients feel they did preserve standing and the claim for standing, and they feel that the trial court was correct and that the law in the case should follow the prior considerations of the GAP case that the Superior Court already decided. And really, we're just springboarding a little bit off of Judge Bo's dissent because...
A little bit.
A lot. Because...
I read the record in this case. The first time that this thought crossed my mind was when I read Judge Bo's dissent. So it's not springboarding a little bit.
It's a lot. I understand, Your Honor. And I appreciate your input. All I can tell you is that as an appellate attorney, I want to argue the law. I can't change the procedural history, which was very convoluted.
Let me ask you this question. Was there any point in time that the trial court's inordinate delay in this case resulted in a change of circumstances that changed the possible ruling on your client's standing? I mean, I don't know why the trial court found that your client had standing, actually, because I think the Superior Court majority pretty clearly set forth what was raised, and so if the trial court had acted any more expeditiously in this matter, would the outcome at any point along the way have been different? I mean, as I read this, I just really wondered whether or not there was some type of breakdown in the court system that caused this morass.
Right. I actually believe the answer is yes, Your Honor, and I think the Superior Court even touched on that in their majority opinion. They talk about the fact that if the trial judge had held a standing hearing in the beginning of the case, that should have happened, as we do in Allegheny County, then they could have ruled on the issue of whether they met prong C for the 12 months and the filing within 6 months, because arguably they did meet that prong depending on your interpretation of whether mother and the child lived with the grandparents. Now, the Superior Court assigned a very hyper-technical definition of living together, and they ruled that they had not met the 12-month, 6-month prong. But they did mention that they might have qualified under 5325 for more custody, and that even if mother had then committed suicide, they would have had, so to speak, their foot in the door. And I do think the procedural deficiencies in the case led to a lot of what we're dealing with today. There were innumerable delays. I wouldn't say the trial court was responsible for all of them. There were a lot of issues of continuances. There was the first appeal that was filed. That created delay. At one point, prior to the appeal, I think paternal grandmother was acquiring new counsel, and there were some delays in scheduling because of calendar conflicts, and that's all on the record. But what ended up happening was you had a 3-year period of time with 4 interim orders being entered in that period of time before a final order was entered. And in all of the interim orders, my clients either had shared with paternal grandmother or primary physical custody, and then shared legal. And then father was always on the periphery, just getting small bits here and there of partial custody. And I think that the impact on this case is, we can't turn back the clock, we can't change the history, but I do think, despite some convoluted pleadings and convoluted procedures that really should have been more streamlined by the trial court, my clients did raise the argument of standing under 5324, and grandmother testified to it, as did her counsel, raising it on the record in the hearing that they went to, on May 14th of 2021, when it was acknowledged that standing had to be addressed. That was in the record on page 64. And maternal grandmother testified that she and her husband qualified for standing under 5324, and that's in the record on page 122. Now, again, did they specifically argue the GAP case? No, they did not. That did not come up until it went on appeal. Did they specifically argue prong B? No, at that time they didn't on the record, but the judge did find that they had standing under prong 3 of 5324, and that's how we ended up on appeal. And I do think the matter is an important one because it goes to this issue of, are we creating a race to the courthouse? If a parent is abdicating their parental responsibility, and then they know that the other grandparents are likely to come into court, they hand the child off to their parent and say, well, you take care of them. And then that grandparent can say, well, I'm taking care of them, they're perfectly safe. And so now the other grandparents can't get in the door.
Well, it wasn't just handing off. I mean, there was a consent order, right?
Well, that's debatable. Our clients took the position on the record that that was manipulated. Mother was in a mental health crisis at the time. They had tried to have her committed about a month. My clients, the maternal grandparents, tried to have mother get help or get committed in May of 2020 because she was indicating suicidal ideation. She resisted that effort. She left their home. Paternal grandmother said, come live with me. Our clients filed a case in July, the petition to intervene, because there's a pre-existing custody case on the record from mother and father from way back in 2011. And paternal grandmother surreptitiously had this consent order drawn up, and her husband's an attorney, and it was drawn up, and mother, who was in a mental health crisis, signed it. But later, mother filed with the court to ask that that be basically circumvented. She was saying, right before she committed suicide, she was alleging that paternal grandmother was resisting all efforts for mother to see the child, was keeping the child away from her, and she wanted that order vacated or changed. Unfortunately, her mental health struggles overtook her ability to proceed, and she committed suicide within a month.
Don't you think that if we're going to wade into a highly idiosyncratic and irregular and convoluted, as somebody said, case like this, we ought to do so in a case where there's preservation and no appearance that standing's been waived?
I mean, in an ideal world, would everyone raise everything perfectly, Your Honor? I suppose that's true, but it doesn't happen in family law that way on many occasions. There's very often changing facts, and people don't know all the facts when they first file, and they run into court with their attorney, and the attorney's trying to get them relief because a child is in distress and a child is at risk. But they did raise their standing issues. They argued them voraciously throughout the case. They asked the court to deal with it, as did paternal grandmother. Both parties were saying we need to deal with standing. The trial court did not deal with it until the end of the case. So that leaves us in a little bit of a mess because we didn't have that clear standing hearing in the beginning of the case. But I don't think my client should be punished for that.
Not only didn't he deal with it, but he kept placing custody in your clients throughout that period of time.
He did, after extensive status conferences, hearings, testimony.
He did it repeatedly.
Yes, and that was also after speaking to the child several times. He involved a guardian ad litem. He had guardian ad litem reports.
He jumped right to best interests, right? He skipped standing.
Yes, he did. As a trial judge, he absolutely did, yes. But he did find it eventually, yes, Your Honor, yes. And I don't disagree. It would have been better if it had been done in reverse, as we're supposed to do. But unfortunately, attorneys can ask the court to do things. The court doesn't always do what they're asked to do. We can't force them to schedule a hearing, as you heard in your prior argument over whether you always get a hearing. You don't always get a hearing from a judge. So everyone had to proceed as the best as they could under the circumstances, and a lot of evidence was put in front of the trial court, both as to their involvement with the child's preference, etc. But in terms of, I just want to address one last thing if we're running out of time, because I can see the questions are winding down a little bit.
We're not running out of time.
Okay.
We're just trying to figure out what on earth to do with this case.
So one last point is, paternal grandmother argues in her brief that the fact that this was raised late in the game, the gap argument, if you want to call it that, she's saying that didn't give her a chance to really defend herself. But the issue here is not paternal grandmother. We're not here to attack paternal grandmother and her involvement with the child. All we're arguing is because father was clearly not involved with the child, that he was still at risk, he was still in a state of neglect, and therefore both grandparents should have been given a chance to be heard. They both raised standing, they both should have been awarded standing, and they both deserve to receive standing under the gap decision. And paternal grandmother can't defend father. She can't change the facts of what father did or what kind of parent he is or who he is as a person. She can only speak to her evidence and what she does. And she will be given that opportunity in this case, as she has been from the very beginning.
Let's try to concise this.
I'm asking you to reverse the Superior Court's decision, or in the alternative, remand, so that standing under 5324, specifically prong B, can be addressed with the Gap case being in the forefront of the consideration for the trial court.
Okay, thank you. Let's hear from your opposing counsel. Mr. Despoy?
Thank you, Your Honor. May it please the court. My name is Terry Despoy, and I represent the Aplt. Now, there is some confusion about Aplt versus Applees. I would like to also indicate my 40 years of practice law is my first time arguing before this panel, so I really appreciate the opportunity, and I've considered it to be an extreme honor and a highlight of my career. 9 days ago, by the way, I was at this very podium arguing a standing of grandparents' rights case as well, so this is a very hot topic. In any event, as you can see, this case is full of confusing facts, confusing law, confusing procedures. And I think the best thing I can do for this panel is to try to make it simple as I can without losing track of what's relevant. Because I think I really, even preparing this case, I found myself going back over transcripts, the pleadings that were filed, the briefs and everything, even though I entered my appearance in October of 2021, so I wasn't involved from day one. But what I'd like to indicate is that what's been alleged here is that the Superior Court made a mistake and should have analyzed this issue of standing by using the GAP case versus JMW and analyzing 23 PACS section 3524 3 III capital B. Perhaps the best place to start to try to simplify this instead of getting caught up in, if I start talking about facts today, with all due respect, we won't be done until tomorrow. I mean, there's just, the facts go different ways and there's reasons for everything. And, but to get a little bit of a glean of the facts here, that the child was born out of wedlock and the mother was in high school and the father was only, I believe, 18 or 19 years of age and was going to trade school. And he wasn't even made aware of the child's birth, didn't know he was a dad until the child was about 6 months. So it started off on the wrong foot and there was contention from day one. But if I could just say, all you need to do is pull the docket. If you think dad wasn't interested, and of course I represent his mom basically, but if you check the docket and you can see the efforts this young man made to try to be a part of this child's life, and he grew frustrated over time because of things that happened. I'll give you one example. He showed up for a custody trial, and guess who didn't show up? His lawyer. And it really put him in a difficult state of mind.
I apologize for interrupting, but I'm trying to understand this. So we're here because your client, father's mother, is challenging the standing of mother's mother, correct?
Correct.
And that's based upon the fact that mother's mother is arguing she has standing pursuant to 5324 3 sub 3B. The child is substantially at risk due to parental use, neglect, drug or alcohol use, or incapacity. Correct?
That's correct.
Tell me how your paternal grandmother has standing to challenge this, considering it's a frontal attack on father, who you said is ready, willing, and able to participate. I'm confused as to that.
Okay, and with all due respect, Judge, and once again, I respect the fact that it's hard for me to even go back over all these facts, but in August of 2021, I believe it was, the mother, father, and paternal grandmother entered into a custody consent order. That was the one that Attorney Calderwood had indicated that maternal grandparents weren't aware of. And that was done in a time frame, quite frankly, and once again, I'm trying to stay away from facts because once again, we can go down a...
Well, we can look at law. When that happened, did mother have any legal custody of the child at that moment? When father decided to enter into a custody agreement with his
Right. With mother, natural mother. Yes, yes, yes. And if I could say one thing, some pushback I was getting last week whenever I was arguing in favor of a grandmother in a standing case was that, well, really, realistically, the legislature seems to have maybe resorted to a policy that's what the parents want kind of governs first, okay? And in that case, make a long story short, my client was the grandma. She had 5 years of time with the child, and her daughter turned against her, and so the enemy of my enemy became my friend, so they both said no, so my client was out of the picture. And so I don't want to get into that because we're not arguing that case, but to maybe carry that over a little bit is that, to really show what the intention was when mom at that time was in strife with her mom because her mom was supporting her mom's her husband who she filed a protection from abuse against, and she didn't want the maternal grandma did not want mom to leave him. Okay, so that was the argument there, and so to try to clarify a little bit, and so when it came to cutting time, let's say, and we have two parents who then felt that among everybody, the best way to handle this situation and have a consent order would be basically a consent order that had custody between natural mom, natural dad, and his mom shared on a week-about basis, basically, okay?
What's before us, if I understand opposing counsel, is despite that consent between the parties, a trial judge independently found for maternal grandmother, without explanation, found standing, and gave maternal grandparents custody plus legal custody.
But that was after mother committed suicide.
Yes. Yes. Okay. So here's what happened. Once again, I'm trying to make this as simple as I can because it's not an easy thing to do. What had happened then? Maternal grandparents started off by filing a petition that they filed 3 separate petitions that happened whenever the child was living with my clients, by the way. The child began residing with the paternal grandparents in March of 20, and quite frankly, the best academic year and a half that this child ever had was the March 20, the tail end of the 2019 to 2020 year, and then 2020 to 21, where the child was under the guidance of the paternal grandparents and grandma, and she actually, whenever that was the year whenever a lot of schools had the homebound programs, and she was teaching the child, and he did very well. He had all A's and B's. And parenthetically, we had a review conference last year, I believe it was, and he was failing under the maternal grandparents. They were having truancy citations issued against maternal grandparents, and he couldn't cope with school anymore when he claimed that he wanted to go back to that school in Tyrone, and he was having extreme behavioral problems, and so all that went.
That's probably the trauma caused by his grandparents and his father.
It's hard to say, Judge, but the point I'm trying to make is that the best year of his life was the year he spent with the paternal grandparents. But
The record, we just heard he tried to kill himself, like those damn reasons.
no, that was after he's taken them. I get it. Okay.
What is it that you're trying to ask us to do?
Okay. What I'm saying is to sustain the Superior Court. They were correct. Okay, because here's why. If you look at the pleadings, maternal grandparents filed 3 separate pleadings that they try to sort of weave about and get standing somehow. The first pleading was dealing with, there was some emergency petition that they filed that they were asking that a guardian ad litem be appointed, and they wanted to be part of the case. They didn't cite one statutory provision as far as how they would have standing at that time. When they filed that first petition, the child was actually living at my client's residence. Okay? So,
And was that challenged by your clients?
well, what happened was, that was one of 3, they didn't have any proceedings until, what happened was they showed up at the first proceeding. I'll get to that in a minute, because the first proceeding that they had would have been at the tail end of the year the school year that the child spent with my clients. That would have been the 2020 to 2021 school year. So, in May of 2021, they had the first proceeding before Judge Clementic, who since retired. In any event, at that time, just before the hearing, there was a second pleading that was filed where they were asking for some form of standing. They were oddly, the maternal grandparents attorney. They changed, maternal grandparents changed counsel somewhere in the spring of 2021, I believe it was. But the second petition, no mention of standing. Third petition was a petition, a complaint to change the custody order. And what they did was they added their name to the caption as plaintiffs, changed around the names of the other parties. Never been a ruling on standing. Okay.
Can I just, on standing, interject? My review of the record indicates that in their June 2020 pleading, they only cited in loco parentis.
Correct.
And then in May 2021, in their custody complaint, they failed to cite any subsection at all, but they used language that mirrors the language in subsection C.
Mm-hmm.
And then finally, on the trial date in July of 2022, they argued in loco parentis and subsection C. And in all three of these instances, I saw no invocation of subsection B. What is it?
3B. That's correct. That's correct.
Am I correct?
You are correct, Judge.
So you're not waiving the waiver, are you?
No.
So why doesn't this case just get tossed?
It should be. I was surprised that the court, granted the L.K.C. order.
Yeah, I was too.
Okay, and but with all due respect, look, I get it, but here's some points I want to make, and I want to follow up on a point you just made, because if you think about it, what you just said, whenever they allege in being in loco parentis, guess what a prerequisite is for this section that they're trying to gain standing under is that they're not in loco parentis. Ironically, okay, and I wanted to point out something else too. All of a sudden, after they didn't get standing in the Superior Court, well, they did for the first time, I guess, initially raise this issue, which, by the way, the argument in appellant's brief is that the Superior Court didn't do two things. One is that they didn't look at the gap case. Two, they didn't do an analysis under this subsection 3 IIIB. I disagree. If you look at it, what they did for two reasons. Number one, gap can be distinguished on its facts. Okay, the distinguishing facts on gap are these. In that case, there was a maternal great-grandparents, husband and wife, who filed under the very section. I mean, they preserved the issue there. They filed under this section that talks about the child being substantially at risk. And why did they do it that way? Because the natural father and mother both had drug addiction problems, and natural father was accused of sexually abusing the 7-year-old grandchild. Okay? That clearly makes a distinction between that case and our case. And what happened was the lower court in that case found that because the child was living, what happened was paternal grandparents then jumped on board later on and filed their own petition to intervene. And maternal great-grandparents filed preliminary objections arguing that they didn't have standing. Paternal grandparents were saying the child's at risk, and they're saying, well, wait, the child's with us now, so you don't have standing. Okay, this child's safe. Lower court agreed. Superior Court overruled it by saying that, well, that issue was already determined by the lower court that the child was at risk, and therefore paternal grandparents had standing then to come in. Interestingly enough, Judge Bose dissented on that, in that opinion, the same justice that the appellants are relying on in their appeal here on the dissent in our case. But in GAP, she found that section didn't even apply. The one that they're trying to argue today does apply. So it really, there's a lot of this that doesn't make any sense. But to get back to the point.
That might agree with you.
But
it's interesting because when I ask my son a very straightforward question, he always goes to, well, what happened was. And that seems to be where you're going. I think Justice Doherty asked you a pretty straightforward question. I think Justice Wecht asked you. You're in a pretty good position here.
Okay, thank you.
I'm trying to figure out why this is an error review. I have not heard a lofty issue. I have not heard the Superior Court failed to follow precedent. I have not heard that the statute needs to be construed. I haven't heard any of these things that we have heard for the past 3 days now, 2 days. I'm also hearing both of you basically arguing that the status quo for this child has changed. And
Sadly enough.
So I am reluctant to issue any kind of a decision in the abstract when the whole circumstance has changed for this child.
It has.
I'm not sure. I'm struggling with what to do on this case. Maybe we IG it. Maybe we vacate the Superior Court decision. But I'm struck with error review that is meaningless.
Yeah, well, here's if I could help you out with that from my perspective, Your Honor, and I appreciate what you're saying, and I apologize if I didn't directly answer the Justice's question, but I want to really get to where maybe the meat and heart of this case is. There was no standing, and I'll tell you exactly why.
Okay, I apologize. We know the Superior Court has said that much.
Right.
And what you're arguing is the Superior Court was right, it didn't commit error.
Correct.
I'm asking you a different question, is the posture of this case is extraordinary.
It is.
And I don't know what principle we should apply, whether the Superior Court decision is now moot, whether we IG it because it was simply error review. I mean, is the Superior Court's decision going to lead to, does it have this long tail where if we don't correct this decision, great injustice is going to happen or uncertainty is going to happen in family law across the Commonwealth?
Right, it's unpublished.
I mean, what are we doing?
I think the simple answer is just to do, if we really just focus on ask yourselves this, did they meet their burden here? Have they convinced you that this Superior Court case should be reversed? It shouldn't be. That's a simple answer. I mean, that's to me is it's the safest. It's the correct way.
It's still going beyond the step where Justice Robson was suggesting we are, and that is, I believe, that we may have improvidently granted the appeal at all.
Yeah. Sure.
It's the same question, if I can rephrase it the same way, that Justice Donahue asked your opposing counsel. Did the actions of the trial court and the way that it adjudicated this case have any impact on the way this case? Not to ask the question.
I remember the question. It did have an impact on substantive impact of where we are right now. Quite frankly, it did.
Hypothetically speaking, if this case were to be IG'd and we affirm the Superior Court, that means child must be removed from his home where he's resided the last 3 years.
No. Well, here's that's interesting. Here's what's happened. To maybe clarify that point. I'm sorry. I'm not used to those. I did.
But see, there are proceedings pending.
Sorry about that, Judge. It must be a bad habit of mine.
But I think the answer to Justice Dockery's question, if I'm understanding what you said, and again, I don't know a heck of a lot about this area of law, and I'll read the statutes and the briefs and all those things. But what I heard someone previously say is there has since been a superseding order that's grandstanding, and notwithstanding the Superior Court's reversal of the earlier decision, there's been a subsequent order that essentially superseded the prior order. I mean, there's nothing here that says there's res judicata or you have one shot at proving standing. Circumstances can change, and that apparently changed. There's now an order that basically is not non-compliant with the Superior Court order. Circumstances change. They have standing. We'll deal with their standing if you appeal that one. But this all seems to be, I hate to raise that word moot again, but it all seems to be.
I'll explain that. I filed, whenever we got the favorable decision from the Superior Court, I was working with the trial counsel to get the child back with my clients. We were trying to have that happen. I was caught off guard by the petition for allowance that was filed nunc-pro-tunc. And so what had happened was I had filed a motion with the Superior Court to enforce its order so that we could get compliance. The lower court entered an order pursuant to the rule of appellate procedure that allows the court in a pending appeal case to enter an order that essentially provides the status quo. I appealed that. It was ruled to be not ripe for appeal. That was what I appealed because we were trying to, the efforts we were making were geared toward getting where we should be. And so that order was only.
Understood, but are you disputing that when your client was, and I completely understand trying to enforce a Superior Court order, I'm completely down with that. But what opposing counsel just said, and again, none of this is in front of us. We're kind of riffing here. None of this is in front of us. Opposing counsel said when your client tried, not only did your client try, your client sent the state police to try and do this and pull that child from the home that the child was in. They filed paperwork with the court and they got a new custody order that gave them physical custody. Is that wrong?
The child threatened to commit suicide.
Is that wrong?
No, that's not what happened.
Why doesn't, that's not what?
That wasn't what happened. That was whenever we proceeded to file to try to get the Superior Court to enforce the order.
Is there a subsequent superseding order that grants them standing in physical custody?
None. There is none, because the only order would be that one that's made pursuant to that rule of procedure that allows the lower court to say, look, we're going to enter this order, that temporary order that preserves the status quo or whatever. I believe that's the language that says.
That's diametrically opposed to what your opposing counsel said.
Yeah. Well,
And are you saying there are no proceedings seeking that, or just that there was no order? I'm trying to figure out what's going on in the.
well, there's nothing going on because of the pending appeal right now.
One would think.
Yeah.
But that's not the impression I have.
The only order they have that allows them to have the child is the order that says we're preserving the status quo.
That's my recollection, Judge. Yes, Your Honor.
Status quo was that they have physical custody of the child.
The child's living with maternal.
If we let the Superior Court's decision stand in this case, the child goes to your client.
Well, okay. No. Well, we'll be in the same position. Yeah, we'll be in this.
Further proceedings in the lower court.
We'll be in the same position we're in, because that'll allow us, quite frankly, to go seek counseling, special relief, or something like that to then proceed. Quite frankly, that will give us if you would do what you just said, that helps.
It's always modifiable.
It is. But some things I wanted to point out. You know, they say about this, all of a sudden this child is in this state of neglect and all this. And if you don't want to hear any more about the standing, if you're satisfied that I've made a convincing argument that there's no standing, yeah, that's where. But
I didn't acknowledge that. I just said we've heard enough about it.
you heard enough about it, okay? Because the point I was going to make, though, you know how they have the indexes now with the words, and the big issue is, this child's been neglect. They talk about parental neglect. There's 750 pages of transcript. Not one time was the word neglect ever uttered in a courtroom or stated, which is the basis that they're here on today, because they're claiming neglect because dad's not been in a child's life. This was never raised.
Well, that kind of sounds like neglect.
In the lower court. But the point is that, and just to cover, once again, I don't want to stand up here and be arguing if you pretty much think you have enough information to quash the appeal or whatever, sustain the Superior Court. If you can tell me I've said enough, I'll leave and sit down. But I just want to make sure that I just covered a couple points that opposing counsel has raised. The one point that she raised, somehow saying that the paternal grandparents are claiming, well, you weren't giving us the opportunity to defend ourselves. We're not here about anybody but the best interest of the child. And so when we have a case and there's an issue raised, the only way a court can analyze that issue to determine the best interest of the child, such as whether or not the child is substantially at risk due to neglect, is to raise it there. That's what I'm saying. That the child is the person that's hurt, not the party that filed this. Yes. Just the GAL. No, they have separate legal counsel. And whether
There was no GAL brief filed for this.
there wasn't, no, I didn't receive one. But to talk about the race to the courthouse, the only reason, if there was a race to the courthouse in this case, was because maternal grandparents chose to file and claim an alleged standing under the statutory provision that requires them to file within 6 months. They chose that. It didn't come about suddenly out of thin air. So I believe that this honorable court has heard enough from me. Just to close, from our perspective, the best interest, the best thing, to do the right thing legally here would be to sustain the Superior Court. Then moving forward, we can maybe try to get some counseling for this child to see where we go. But that's where I see it going from my perspective. Thanks.
Thank you both. Very nice. Can I just clarify one thing? Okay, thank you.
Okay. Justice Lundy has requested to hear from you, so
Oh,
go
I'm
ahead.
so sorry, I didn't hear. Thank you, Your Honor, I appreciate that. I just want to clarify, I did not mean to mislead the court in any way. There was a subsequent order entered in November. I was not saying they granted standing. They did preserve the status quo there by giving my clients primary still. That was all I was trying to say before. I didn't want anyone to think I misled the court.
Thank you.
Appreciate that, Counsel.
Mr. Minner, would you call the next case?
Penny Gustafson versus American Federation of State, County, Municipal Employees, Council 13, representing AFSCME, Ms. Amy Rosenberger, representing Ms. Gustafson, Mr. Logan Hetherington.
In this case, Apelt was an employee of the Department of Human Services. She was part of a bargaining unit for purposes of collective bargaining and was represented by Appellant, the union representing that bargaining unit. However, Apelt was not a union member. In resolving a grievance involving the employee claims the union discriminated against her because she was not a member of the union. In this appeal by allowance, we consider whether in a claim against the union for breach of its duty of fair representation, the employee is limited to the remedy of arbitration, or whether other damages are available. Please proceed.
Thank you, Madam Chief Justice, Justices of the Court. May it please the Court, my name is Amy Rosenberger. I'm here today with my partner Jessica Caggiano, and together we represent the appellants in this matter, AFSCME Council 13, District Council 83, and Local 2047. At its core, this case is about the adequacy of the make-whole type of remedies that our legislature has chosen for collective bargaining and labor relations matters in this Commonwealth. This court, in the Martino case, that is sort of at the core, also at the core of this case, determined, based upon the legislative context, that an order compelling arbitration is a complete and adequate remedy in a case like this one, where the union is alleged to have breached its duty of fair representation to an employee, particularly in the context of handling a grievance. The Martino court held that, or explained the reason why this is a complete and adequate remedy by saying that under this procedure, the employee, quote, receives precisely the treatment that all the employees in the unit are entitled to under the collective bargaining agreement.
Could I just stop you there a moment?
Yeah.
What's concerning me a little bit is, in a case like this where it's a non-union member who the union is to be acting on behalf of in a grievance, is the fact that the remedy is arbitration, which is what she would have been entitled to anyway, is that any remedy at all, really? I mean, does that allow the union the opportunity to never act in good faith on if it were inclined to never act in good faith on behalf of a non-union member when the only remedy is no remedy? It's arbitration.
Well, I'm sorry, I'd respectfully disagree that arbitration
I figured you would. I just wondered if you would explain.
is no remedy. In
Martino suggests it is a remedy.
Yeah, it does.
It not only suggests, it declares that it's a complete and adequate one. And in the context of labor relations, that's the way make-whole remedies are. They are a remedy that requires the offending conduct to be undone and for there to be either a redo or sometimes the remedy for the offending conduct in this under our remedial statutes for labor relations in Pennsylvania is cease and desist. I certainly understand the sentiment that to an employee may not feel like a fulsome remedy. We deal with cases every day where an employee is perhaps fired or maybe improperly furloughed, and they learn that if we win at arbitration or if it's an unfair labor practice charge, that they're going to, if we win, let's say in a furlough case, the furlough will be, the furlough process, the seniority-based bumping process, is going to be redone. And if it's determined that when it's redone, you shouldn't have been furloughed, you're going to get reinstated, and you're going to get back pay minus what you've earned during the interim. You're not going to get compensated for having not been able to make the payments on your car loan or your mortgage or emotional distress or punitive damages. That's not part of the remedial framework of remedies that our legislature chose for our collective bargaining laws.
Counsel, maybe you could clarify for me. This is a common law action in the Court of Common Pleas based upon a decision of this court that preceded PERA by many years. Zaccarelli preceded the PERA. I'm sorry. Falsetti preceded the PERA.
Falsetti preceded the Public Employee Relations Act, yes, by about 10 years.
Okay, let me finish my question. So, and just tell me if I'm misunderstanding the case law, because it's obviously possible, but in Martino, the employee wanted arbitration. She sued her employer and the union because what she wanted was essentially reinstatement, which could not happen outside of arbitration and outside the presence of the employer in that case. So she didn't seek, or he, I don't know, Mr.
He, Nicholas, I assume he.
Nicholas did not ask for money damages.
Yes, he did.
Against the employer.
That's correct,
But
not against the employer.
But not against the union. So Martino.
No, he asked for money damages against the union.
Oh, I thought the money damages were claimed against the employer under 1983.
He might have had a 1983
Okay, well,
claim.
but
That's the Zaccardi case.
Let's take that out of the picture. I mean, what the employee wanted that in that case was to be reinstated. The only way that was going to happen was through the arbitration process. If I recall correctly, the employer in that case, that's what the requested relief was. I want the arbitration that I didn't get so that this wrongful termination can be corrected and I will be reinstated.
Vis-a-vis the employer. He sought damages against the union, and the determination of this court was he got...
It was ordered to arbitration.
Right.
Because the only way the relief of reinstatement could take place is through the arbitration process. Is that not correct?
That's not the reason it was ordered to arbitration. The reason it was ordered to arbitration is because this court determined that to get to the question of whether reinstatement is appropriate, after first determining whether there was a breach of the duty of fair representation, bad faith conduct, required an interpretation of the collective bargaining agreement. And under Section 903 of the Public Employee Relations Act, the sole venue, the exclusive venue for resolving those disputes is in labor arbitration.
That's what the trial court determined in this particular case, was it not?
That's correct. The trial court...
That's the whole concept of the case within the case. In other words, he doesn't get what he wants to get from the union unless he can prove he's entitled to damages in the underlying case. In this case, against the employer, because I believe what he was asking for was equalization and overtime. He got equalization, or is it he or she?
Ms. Gustafson.
Yes, I'm sorry. The employee got equalization, didn't get the overtime that they were entitled to. The only way they could get that is through arbitration with the employer named, and if they won that particular case, then theoretically they get damages against the union, correct?
Correct that in general about what the trial court said. I am sure that my opposing counsel would quibble a bit with the statement of the underlying facts of what happened.
I like quibbling.
But the ultimate, what happened at the trial court here is that the court applied Martino, determined that to decide whether or not there are damages as a result of the breach, that question of the interpretation of the collective bargaining agreement has to be resolved at arbitration.
And the only way you can do that is by naming the employer, because then they would have to prove the entitlement to overtime from the employer.
That's correct. I mean, the employer is an indispensable, according to what this court has ruled, is an indispensable party in that sort of a case to get the order compelling arbitration.
Here's my question, because you're going to get this from somebody else. Here's my concern, I shouldn't say a question. We order this thing to go to arbitration. The only entity that is entitled to arbitration is the actual union and the employer.
That's right.
How does the union represent in good faith the employee in the arbitration proceeding? Shouldn't the employee be entitled to retain her own counsel to represent her? Because theoretically, if the union wins at the arbitration, aren't they setting themselves up for a claim of breach of the duty of fair representation?
They will have already litigated the breach of the duty of fair representation.
You're saying
if
it's
they
litigated
win
within the confines of the arbitration. Wouldn't they be litigating it against themselves? In other words, wouldn't there be a conflict there?
I don't believe so for a couple of reasons. First, I wouldn't presume that any party to a court proceeding would violate the court's order in a case by not proceeding in good faith. But secondly, that type of a remedy or the concerns raised about that type of a remedy are no different than what concerns might be raised in any sort of make-whole remedy. So, for instance, let's say in this case that what the employer had done was to remove Penny Gustafson from direct patient care, or took her off the floor, to use the terms in the complaint, and deprived her of overtime opportunities, which is the basic nub of the issue, and that the reason that the employer had done that was because the employer was discriminating against her for resigning her membership in AFSCME. That the employer liked the union, liked dealing with the union, and didn't want to treat her the same, thought they'll show her. The remedy for that, if the employer had done it, whether they did it in whether it was litigated at arbitration or in an unfair labor practice, would be to make her whole, would be for the employer to cease and desist from the discrimination, which we can't assume the employer wouldn't obey that sort of order. I certainly wouldn't presume it if it came from a court, and make her whole, put her in, to use the terminology from Martino, receive the treatment she should have received. Every employee under the collective bargaining agreement should receive. That
cause of action for a breach of the duty of fair representation is independent of the case within the case. My analogy, and I'm thinking of this out loud, would be if I was sued, if I blew a statute of limitations as a private attorney, and I had to sue myself for legal malpractice, or I had to bring a legal malpractice claim, I got to prove the case within the case, right?
Yes.
Would we, as a bench or the Bar Association, allow an attorney who was the subject of the underlying legal malpractice to represent the plaintiff in the legal malpractice action against himself? Because in the situation we're talking about here, if we go to arbitration, the union's going to represent Ms. Gustafson in that arbitration. And the remedy is going to be the cease and desist order, and she's going to get a check for the lost overtime if they can prove it, right?
Yes, if they can prove it, yes.
Now, if you prove that, couldn't she independently file a cause of action against the union for breach of the duty of fair representation? Or is it your argument that if you're successful in that case, it forecloses any breach of the duty of fair representation?
That case is the result of the breach of the duty of fair representation claim. If we get to that point in this case, it will be because, to get to that point, she must first prove in the trial court that the union had a duty to fairly represent. I mean, if we're looking at this through the tort lens that plaintiff's counsel does, that the union had a duty, which they do under that duty is from PARA, from 606 of PARA, as the exclusive bargaining representative, and that it engaged in bad faith discriminatory or arbitrary conduct in breach of that duty. Once those two elements are proven in the duty of fair representation case, then the remedy, according to the Martino court, is arbitration. So no, a successful result at arbitration doesn't then send it back to court. It's the damages and causation part of, if you're looking at it through a tort lens, of the analysis.
I'm sorry if I'm monopolizing. I'm just trying to think this through. Your position is then that the ordering this matter to arbitration is, in fact, the final remedy. There's no independent cause of action against the union for actual money damages or some type of tort damages.
Correct. And
I just wanted to think that through.
What may help to illustrate is, and this is really, I was going to talk about this more in the context of that, and that addresses perhaps your question, Justice Donahue, about whether Martino actually applies in a situation like this where the employee isn't asking for arbitration or...
Nor did she sue the employer.
Correct.
My understanding under Zaccardi is that she didn't have to sue the employer.
Well, Zaccardi is pre-Martino.
2 years. I mean, are
Yes.
you saying, my understanding is Martino clarified or made an exception to the general rule in Zaccardi, general rule being you don't sue the employer. There's no right to sue the employer. Martino said there is, and you must, if the only way an adequate remedy could be afforded is to proceed to arbitration. She is not seeking that. And so I guess and I don't know, you keep saying if you look at this as a tort. This is a tort. It's a tort. It's a common law cause of action.
It is.
I'm not sure that hurts you or helps you, but I mean, it's a tort.
The reason I said if you look at this as a tort is in thinking about traditional tort damages, which the Martino court found a different remedial framework than what we would think of in, say, a personal injury tort.
Okay, well, I thought they looked at it as in a different framework because of what damages she requested. Not because, as a general rule, this was the damage that always had to be relief that had to be afforded.
Well, let me respond to that by pointing to another case, a post-Martino case, which I think is the last time that this court actually weighed in on the question of the remedies in a duty of fair representation case under PARA, and it's the Runsky versus AFSCME case that was in the Commonwealth Court in 1991, affirmed by this court in 1994. So it is also a while ago, but 10 years more recent than Martino. In that case, a state correctional officer who was represented by AFSCME filed a duty of fair representation claim in the Court of Common Pleas, alleging that the union, only against the union and only seeking damages. He alleged that the union breached his duty of fair representation by not sharing with him an agreement between the union and the Commonwealth Department of Corrections that was basically about staffing and not applying the agreement in a way that it would have allowed him to work on a particular cell block at what was then called Western Penitentiary. And he alleged that as a result of what the union did, he suffered physical injuries on the job, and he was seeking damage. He wasn't seeking assignment to the cell block that he had wanted to be on. He wasn't seeking reinstatement because he was out of work for his injuries. He was seeking damages from the union. The Court of Common Pleas in that case, like the Court of Common Pleas here, told him, you need to join the employer as a party under the remedial framework. He did.
Because the only relief that could be granted there, in the context of a breach of a duty of fair representation, was reassignment to that cell block. Answer this question for me. What damages is the plaintiff claiming in this case?
Contractual damages.
Okay.
Lost overtime, essentially.
Okay. Well, that's not personal injuries.
No.
Which is what Runsky was.
He was looking for damages from the union.
Personal injury damages.
I don't know. The case doesn't say whether it was, emotional distress, that kind of thing, but damages as a result of his injuries. The case, because he did as he was told by the Court of Common Pleas, joined the Commonwealth, it then got transferred to the Commonwealth Court sitting in its original jurisdiction. And the Commonwealth Court, in its original jurisdiction, looked at the case. It's still only seeking damages. He's still only seeking damages, not seeking any sort of non-monetary remedy. And the Commonwealth Court in that case says that when there is that Martino means when there's a breach of the duty of the union's duty of fair representation, the employee's sole remedy in court is an order, when it's in a grievance handling case, the sole remedy in court is an order compelling arbitration, and so the employer is joined. And the only exception to that, which we haven't actually mentioned yet today, is when there's evidence that the employer and the union were in cahoots, basically, were conspiring against the employee. That case, both the employer and the union filed preliminary objections. Both of their preliminary objections were granted because in his case, he didn't allege sufficiently conspiracy, and this court affirmed that decision. That reading of Martino as applying to all duty of fair representation cases.
Remind me how we affirm that.
In a per curiam order.
Counsel, can I jump in here real quick? I think I understand your point. Is it doesn't really matter what remedy they're seeking in a breach of fair representation claim. Whatever, it eventually has to go to arbitration after the Common Pleas Court or the Commonwealth Court make a determination there was a breach of the duty of fair representation.
Correct.
Okay, I get it. Question is, in that paradigm, I'm going to struggle with my words here. How is the union disincentivized from breaching the duty of fair representation?
Which is an artful way of asking what I asked a while ago.
Much more artful.
Very concise.
The union is disincentivized from further breaching its duty of fair representation.
I'm not saying further in that case. I'm saying in any case. If we say that at worst, what's going to happen to the union in a breach of duty fair representation case is they have to represent the interest of the employee to whom they breached the duty in arbitration. Why wouldn't a union just take a flyer and breach it? I mean, the worst case scenario is they go to arbitration.
That's what you're describing. Is one could just as easily say, why does an employer agree to anything in a collective bargaining agreement when the worst that's going to happen is, if they flout it, is they're going to end up in arbitration?
No, the worst that can happen is they're going to end up arbitration and lose and have to pay. Here under your scenario, the union loses nothing.
Well,
the union breaches the duty of fair representation. A court says they breach the duty of fair representation, and the only remedy you're saying that our court has ever said you can ever get in a breach of duty of fair representation claim is to order the union to go to arbitration. And the union loses nothing.
Well, the court also says that at that arbitration, the Martino court says, at that arbitration, the arbitrator determines first whether there's been a contract violation, causation, and second, how the damages, if there are any from that contract violation, are to be apportioned between the union and the employer.
Now you're getting to the second point I asked. So you concede that that you're not saying the union gets a pass.
Correct.
You're saying that if the arbitrator awards damages, whether it's back pay, whether it's overtime pay, whatever the collective bargaining agreement allows the arbitrator to do, and sometimes they're pretty flexible, the union can be on for all of it, half of it, a quarter of it, whatever the arbitrator says goes.
Yes, the arbitrator has broad discretion in remedying the contract
Well,
violation.
in that case, the arbitrator doesn't have the discretion to remedy it with the union. It'd be part of a court order. If we ordered the employer, we'd be vesting in the arbitrator authority to apportion damages partially to the union. That's not in the collective bargaining agreement, and it's certainly
That's
not
correct.
in PIRA. So this is court-created stuff.
That is correct.
And you're okay with that?
It's what Martino says. We have lived under the state of the law with Martino for 40 years. And the Runsky case isn't the only case where that's been where it's been read that way.
You're fine with it, I get it. I do have another question, though. You said in Runsky
Yes.
that the trial court gave the Commonwealth the opportunity to, or gave the plaintiff the opportunity to amend the petition to name the Commonwealth and transferred it from the Common Pleas to the Commonwealth Court.
Yes.
Why didn't that happen here?
Well, what happened here, prior to this iteration of the case, the same parties were party to an earlier iteration of the case. In that case, Ms. Gustafson had sued both my clients and the Commonwealth in the same Court of Common Pleas, and for breach of the duty of fair representation, seeking damages or an order compelling arbitration. The Court of Common Pleas in that case granted the Commonwealth's preliminary objection that said for the equitable relief, the original jurisdiction belongs in the Commonwealth Court, for us, the Commonwealth. And so the court transferred the case to the Commonwealth Court, and shortly thereafter, that case was withdrawn, and the next day this case was filed.
And like I said, that was the final question. It isn't the final question.
You're
When you go to arbitration and the arbitrator is asked to apportion fault between the union for its breach of duty of fair representation and the employer, who represents the claimant's interest in the breach of duty of fair representation damages? Because the union's going to argue the employer should be on the hook for 100%. Who's going to argue on behalf of what the claimant says is proper?
the parties to the arbitration, because the parties to the contract are the union and the employer. Martino doesn't address that question specifically, although it is the union that is the party to the arbitration under the Martino framework.
But the apportionment was not created under PIRA. The apportionment part of Martino was not created under the arbitration agreement. The apportionment is created by us. Correct. And so your answer is no one.
No one who's a party to the arbitration. That's correct. The way it is under the framework created by Martino and followed for 40 years until now by our appellate courts. That's correct.
Counsel, can I ask one question about Zaccardi? And you know these cases like the back of your hand.
I've been working with them for 30 years.
What was the complaint in Zaccardi?
In Zaccardi, that one was a discharge case, I believe, and she brought a number of claims. That's the one where there was a Section 1983 claim, and there was a breach of the duty of fair there was breach of contract. That case stands for the proposition, among others, that an employee cannot bring a breach of the collective bargaining agreement claim directly against the employer in court. It's also the case that gives us the origins of that exception I mentioned about damages. The employer.
What was the grievance? I guess I should have.
Let me just double check. I don't want to speak. Wrongful discharge. So discharge without just cause. I would mention that there is another case in the chronology of the cases that also dealt with a claim, to your earlier point, Justice Donahue, against a union only seeking damages against only the union. And actually in that one, it was the plaintiff brought breach of contract, fiduciary duty, and DFR, a duty of fair representation claim against the union. That one is the Wachlet-Riker case that's cited in, I think, both our briefs. That is, was in the Superior Court. It came after Runsky. It adopted Runsky's articulation of the rule from Martino. So again, one where it was in Superior Court because the employer was not a party. Determined that, in the court in that case, determined that the only claim that's available is the duty of fair representation claim, even against a union, not a separate fiduciary duty claim, not a breach of contract claim.
And what happened with the case you're just referring to when the employer was not a party?
In that case, at the Superior Court, ultimately, although they adopted the framework, they ultimately sustained the granting of preliminary objections because the plaintiff had not alleged bad faith sufficiently. So I do want to say a little bit about
Counsel, before you move
yes.
on, can I just ask a question? Could
Yes.
you just jog my memory on something? Are you aware of any cases where monetary damages have been awarded against a union by a member or a non-member for breach of a duty of fair representation?
Not where they have been awarded, but the only case where a damages claim solely against the union.
I've never heard of it.
There's one case where a damages claim solely against a public employee union has been permitted to proceed without the employer being involved. And that's the Lynn versus Pennsylvania Social Services Union case that's also, I think, cited in both of our briefs. That case, however, the plaintiff had a convoluted history at the Court of Common Pleas, but by the time it got to the Commonwealth Court, he was alleging the conspiracy exception.
Right, the collusion.
Collusion.
Between the union and the employer.
Correct.
Right,
Yes.
That was my question.
So that
Normally speaking, a DFR complaint is usually made through the NLRB. It's an unfair labor practice, isn't correct?
Well, in the private sector.
Right.
Correct. In the private sector, and that's part of the Martino Court distinguished our public sector framework based on the legislature's judgment from the private sector. In an earlier case, the Supreme Court had decided not to follow the private sector approach of allowing a duty of fair representation case to go forward as an unfair labor practice charge because it's not explicitly mentioned in the unfair labor practices listed in para. But also in the private sector, there is an option to go to court, but it's under there's a specific federal statute that grants the federal court's jurisdiction over breach of collective bargaining agreement disputes.
Non-public employees.
That's only in the private sector, yes, so non-public employees. And it was the distinctions between the statutory framework for labor laws in the private sector, the federal labor laws, and the statutory framework under our state public employee collective bargaining laws that was the foundation of the Martino remedial framework. And the other thing I wanted to say about that the way the legislature set up our collective bargaining laws in Pennsylvania, without which this claim for breach of duty of fair representation couldn't exist if there weren't the collective bargaining laws that provide for representation by a union. The legislature certainly knows how in employment-related legislation to provide for a broader panoply of remedies when it views that to be in the interest of the public. So, for example, under the wage payment collection law, there's obviously back pay. There are make-whole remedies, back pay, but there's also liquidated damages and attorney's fees and costs provided for under that statute. In the Pennsylvania Human Relations Act, there's, of course, back pay and reinstatement, typical make-whole remedies, but also uncapped compensatory damages and attorney's fees and costs. They chose not to allow punitives under that statute, but they didn't provide for that type of a remedial framework when it comes to the collective bargaining laws in Pennsylvania. And we think that's significant, and if there's to be a change in that, in the overall remedial framework to allow other types of damages claims to go forward or other types of remedies to go forward, that's a question to be taken to the legislature. I do want to say a little bit about the assertion by Ms. Gustafson and by the Commonwealth Court as well that the employer had no involvement here whatsoever. The fact of the matter is we wouldn't be here if it were not for the actions of the employer. It is the employer who deprived Ms. Gustafson of the overtime opportunities that she is, the loss of which she is challenging in this case.
But it was the union that
Correct.
delayed the acquisition of a remedy, delayed the proceeding with it.
That's
She wasn't a union member.
allegedly.
Well,
Yeah, I mean, at the stage,
According to
the complaint,
spokesman.
according to the complaint, because we're at the stage we're at is at preliminary objections. So,
So he may not have called her a freeloader and a sponge. He may.
He may have, he may not. I mean, we have to assume that he did, right? That even plaintiff asserts that those comments are evidence of motive, of the bad faith motive, not necessarily actionable in and of themselves. The harm, the harm that she seeks to remedy is
The delay.
is the lost overtime.
Yeah.
Yeah, and on the issue of delay that you've raised, Madam Chief Justice, the delay is the issue that comes into play in the Martino case with regard to apportionment of damages. So it's perhaps in some ways a more straightforward example is where there's a discharge and there's back pay. The delay increases the back pay period, so the employer's not on the hook for the increase.
So if we can order, if we as a court, again, I think we're making a lot of this up. If we can order as a court the employer and the union to arbitration after all the periods have expired for arbitration and arbitration of a grievance, and notwithstanding a settlement agreement that would arguably be binding in contract, all these fun things, we're just going to ignore all that, and somehow the courts have the power to order an arbitration to happen that basically the collective bargaining agreement forecloses due to time or agreement or contract. We're able to do that because Martino says we can do that. And we're able to imbue the arbitrator with this power to apportion damages between the union and the employer, notwithstanding the fact that there's nothing in the collective bargaining agreement or PIRA that provides for that. Can we augment Martino and say, this remedy's fine, but the employee or the claimant is either allowed to have their own representation, which the union has to pay for, or the claimant is allowed to separately and independently participate in the arbitration agreement to ensure that the union is fairly representing and arguing in favor of apportionment?
So I want to first address the premise of your question, and then I will answer your question. The premise of your question that the court is making all of this up, I don't agree. Make-whole remedies are designed to, in the words of this court, put the employee, or maybe not exactly in the words of the court, but put the employee or put whoever the union, if it's in a dispute between the union and the employer, in the position they would have been in but for the offending conduct. So, for example, if an employer violates its duty to bargain with the union and subcontracts the bargaining unit work without first bargaining with the union, the remedy for that, typically, the make-whole remedy for that is rescind the contract, the subcontract, return the work to the bargaining unit, and then go and fulfill your duty to bargain with the union in good faith. And when that remedy gets imposed, it is expected that the employer will comply with it. And the fact that there was a contract that was entered into that's now going to be rescinded is part of, it shouldn't have been entered into, so it should be undone because the employer did it unlawfully. That would be the same sort of make-whole framework we would be in here. To find, if there is a finding, ultimately, that the union's settlement was unlawfully entered into, then it's essentially rescinded and the parties are directed to fulfill what's under the contract.
Under Martino, this court has said that the arbitrator has the power to apportion, we're not talking about reinstatement, well, it could be reinstatement, it could be reinstatement plus back pay.
Right.
But that's not returning everybody to the status quo prior to the breach. That's imposing an additional power imbued upon the arbitrator to do this apportionment, which maybe it goes beyond make whole, maybe it doesn't. I think there might be a remedies clause issue because there's got to be a way to address the alleged wrong by the union. But I'm asking you, if we can imbue an arbitrator with the authority to remedy a breach of the duty of fair representation by apportionment of damages, can we imbue the arbitrator with the authority and jurisdiction to allow the aggrieved union member to participate?
I have to say, that's not a question that I have to think about that one for a minute. That wasn't one I had thought about. The arbitrators, I've been in situations where arbitration, where an aggrieved employee, where a union is representing an aggrieved employee, and the aggrieved employee wants to bring their own counsel to the arbitration, and the arbitrator, if the employer opposes that. So I've been in a situation where the union didn't oppose it, the employer did, and the arbitrator had authority to decide whether or not to permit that, and have permitted it, not permitted it. I've actually had a grievance arbitration with the employee's lawyer looking over my shoulder because the arbitrator permitted it. So I think that is within the arbitrator's discretion now to decide whether to allow that.
If the arbitrator has the discretion to do that now, nobody's going to be offended if we start putting it in our Martino framework.
If it's in the discretion, I can't tell you nobody's going to be offended, but if it's in the discretion, I believe it's in the arbitrator's discretion now. And if the court, what Martino says is, the arbitrator apportions the damages that he or she finds, or they finds. And so, that's within the arbitrator's discretion. It seems to me that a court order that puts this question within the arbitrator's discretion would be stating something that they arguably have discretion to do now. Well, I see it as two different things. So one, you would agree that the arbitrator currently does not have discretion to hear an arbitration that is untimely. That goes to the jurisdiction of the arbitrator. Barring the parties agreeing to.
Okay.
Yeah.
So Martino is a court-created paradigm that forces the parties into arbitration that contractually they're not arbitrated to go to, and arguably the arbitrator lacks jurisdiction because it's untimely.
But the arbitrator doesn't because it's being ordered by a court. But
Okay.
Yes, I see what you're saying.
But my point being is Martino orders that.
Yes.
Something the arbitrator has no discretion to do. But for the court order, the arbitrator wouldn't be able to do it.
Correct.
So it's less offensive to order the arbitrator to exercise jurisdiction in a certain way, or exercise discretion in a certain way that the arbitrator already has.
I could see that being viewed that way.
Okay. Thank you.
Okay, do you want to wrap up?
Certainly. I would simply conclude by saying we believe that the Court of Common Pleas in this case properly applied Martino, and that this court should reverse the Commonwealth Court's contrary decision and reinstate the Common Pleas decision. Thank you very much.
Thank you. Let's hear from Mr. Hetherington.
Good afternoon. May it please the court. Logan Hetherington on behalf of Appellee and plaintiff below, Penny Gustafson. I'm joined by my co-counsel, Nathan McGrath. I want to turn to Martino and some of the points that Justices Brobson and Donahue made about Martino and relief in particular. The Martino decision never stood for the proposition that all duty of fair representation claims must include the employer and limit relief to arbitration nunc pro tunc. It never stood for that proposition. It doesn't stand for that proposition today. It merely recognized, and this is the paradigm that Justice Brobson pointed out, that when an employee's requested remedy requires the public employer and the union to resolve an underlying grievance, arbitration must be the vehicle to do so. Why? Because it requires some action by the employer to make the worker whole. And this has frequently come up with the reinstatement case, right? If an employee loses their job, they don't think it was for just cause in violation of the CBA, but then to add on top of that, the union comes in and says, well, employee, you're a Muslim, so we don't want to represent you. At that point, they've committed a breach of the duty of fair representation. Now, if what that employee really wants is to go back to work for the Commonwealth or that public employer, what they must do is ask for reinstatement. And the only way you're going to get reinstatement is through arbitration. And that's all Martino stands for. It doesn't undermine the baseline of what the duty of fair representation is, as it has stood in Falsetti, as it was repeated in Zaccardi, and that is when a union breaches its fiduciary duty, and I'm stressing that point, it's the union's fiduciary duty that's breached here. When it breaches its fiduciary duty of fair representation to a public employee, that employee may file an action against the union seeking damages. Turning to another point that came up here, in this case, yes. And my answer to that is no, I'm not, and I think there's a real good answer for that. And it's because to succeed on a duty of fair representation claim, it's a high bar. It's more than, I mean, we've analogized this to kind of a malpractice, and you mentioned the case within a case because, correct, and that's what would happen here is you file the claim, you prove the breach of the duty of fair representation, and then to determine damages, you engage in some form of opining on the merits of the grievance. That's correct, just like you would in an attorney malpractice case. No, not in a, think of an attorney malpractice case, right? When an attorney commits malpractice, you don't join the underlying party to the previous suit. If, say, the attorney messed up and blew the statute of limitations, you're not going to haul in that party that they should have sued.
But you've got to prove in the underlying case, using your analogy, you still got to prove negligence. In other words, I would still have to prove the underlying case.
Sure.
In this particular case, you have to prove, or your client would have to prove, that there was a breach of the duty of fair representation, and she otherwise would have been entitled to the lost overtime, and the lost overtime is payable by who?
In this case, the lost overtime would be payable by the union because it's the union's breach that got us to this point.
Why didn't you just file in the arbitration? I mean, if what she's looking for is nothing more than this lost overtime, why don't you just file an application for an order for non-pro-top arbitration?
Well, in this case, I think there's a couple things that prevent that. One, we're not talking about a case where this is reinstatement, where what she's seeking is that.
You're asking for damages. You're asking
Sure.
for lost overtime. Let's box that. Let's catch
Sure.
it. Who's the lost overtime in arbitration get paid by?
It would be paid by the employer.
So why didn't you just file for arbitration seeking lost overtime from the employer?
Because the wrong that was done here was the discrimination against Ms. Gustafson committed by the union. Not anything that the employer did. Yes, the employer took her off the floor, but here's the key, and here's one factual distinction I think I need to bring out. What happened in this case was a grievance was filed. Then what the union did, as alleged in the complaint, is instead of, litigating that grievance, they settled it on terms less favorable to her than they would have for a member of the union. They didn't give her the full equalization. There's lost pension credits also at stake here that she would have gotten, and of course the overtime. But what a duty of fair representation claim really allows her to do is to seek more than that. She can ask for nominal damages. That's also the important point.
That's why I started off asking the question. Have you ever seen any cases in Pennsylvania where nominal damages or damages outside of what you're talking about lost overtime and lived against the union?
I have not, and again, Your Honor, I think that's because it's a high bar to meet. It takes a lot to prove it. No one is saying that, there's a lot of bad actors out there discriminating against people, but I think the concern is that there may be rogue union officials who may do something like this. And to get to an earlier point about a meaningful remedy, if all we're going to do is send it back to arbitration, the union is never going to be on the hook for what it did. And we really truly can run into a Groundhog Day situation where, say, the union says, well, you're not going to get good representation from me because you're not a member or because you're a Jew. Sure, then we go to court. The court slaps them down and says, hey, you can't do that, but we can only send it back to arbitration. Now we go back to arbitration, and guess what? You're stuck with that same union official that already insulted you.
What about a situation where, because Justice Robinson's correct, we're kind of making this up on the fly and creating our own paradigm? What if we were at arbitration and allowed Ms. Gustafson to bring her own attorneys into the arbitration?
I think that the union would have a problem with that, and at that point, I think we really are conflicting with some of the provisions of PARA. Because under PARA, the union is the exclusive representative, and with that, they have a great power. At that point, you're essentially rewriting the statute and saying, well, PARA doesn't apply at all in this case. And that brings me to another point I think that needs to be hashed out here, which is neither the union nor any of its amici in this case has argued that the line of case is holding that the public employer may also be liable in damages, right, if it participated in the breach. No one has argued that that was wrongly decided. So if the courts of this Commonwealth are willing to say, at that point, PARA is not invoked. We're not going to send it back to arbitration because the employer committed this breach too with the union. We're turning it on its head if we're saying, but if it's only the union that committed the breach, it must go back to arbitration. At that point, where is the real remedy? Where is the real, and again, I think this court has aptly recognized, Justice Donoghue in particular, that this is a common law tort. The point of a tort is to remedy a wrong and arguably to punish people for committing those wrongs. And that is why this case has developed the way it has under common law. And frankly, Your Honors, what the union is asking for really undermines and kind of eviscerates the principles of the duty of fair representation as they have been interpreted and enforced by this court for decades, going back to Falsetti, which, yes, predates PARA, but Zaccardi does not. Zaccardi was after PARA. And it really rests on a fundamental misunderstanding of what this claim is. The claim isn't something that arises out of the interpretation of a collective bargaining agreement. The gist of the action is the union discriminated against this person for whatever reason. That is what the gist of the action is. It's not that it arises out of some interpretation of the agreement. And again, I think it's really analogous to a legal malpractice claim. Yes, to determine damages, you have to go back and you have to opine on that. But courts do that all the time. This is nothing new in this Commonwealth. It can be done. So what we're really asking for is that we just uphold the state of the law as it is now.
What would you have to prove in your case within a case? What's the within a case you'd have to prove?
Sure, we'd have to prove that she would have likely succeeded at arbitration.
And how would you prove that? What comes into play?
The collective bargaining agreement.
And where does the court get the authority to interpret the collective bargaining agreement?
It's inherent in its ability as a court sitting, not in equity in this time, but sitting in law, can take a look at that and say, this is how it would work. And again, we're looking at it, again, this is something, we do this all the time in cases like legal malpractice, where the court will come in and say, we're not going to disturb what happened below. And to Justice Robson's point, I really think we're stretching if we can say that a court can go back and say, in this case in particular, right, the union entered into a settlement agreement. As far as the employer was concerned, this was resolved years ago. They no longer have any skin in the game, and what the union wants to do is to draw them back into court years after the fact, and then ultimately, at arbitration, hold them liable for this, and make them the party that's on the hook, as opposed to the union, when really what's at issue here and what matters to my client is the way she was treated by the union.
Well, and you left out a key part, obviating a contract.
Yeah, exactly.
Because a settlement agreement is a contract.
Correct.
They settled the grievance, and they are asking to basically bring the employer back, and even though there's no alleged culpability of the employer, that the employer doesn't get the benefit of the employer's bargain.
Precisely. So not only would they pretty much say the settlement agreement is out of the window, but they're also going back and saying, hey, all these deadlines that applied in the collective bargaining agreement for the time for arbitration or the time to challenge a settlement agreement, they don't mean anything anymore. And I really, at that point, again, you're turning para on its head and you're saying none of these collective bargaining agreements matter. There is not. The union controls the grievance process, and that is why the duty. They do, Your Honor, and I respectfully, I think you answered your own question from earlier. That's why we don't have many cases on this, because it's easy for a union to come in and determine, and they have a lot of experience in this, and say, well, we're not going to take your case to arbitration because we think it's frivolous. There's never going to be a claim that lies under the duty of fair representation for that. Where the claim would lie is where there is a meritorious case.
You're asking us to say that every time an employee isn't happy with the settlement of a grievance, that they then can file a lawsuit in the Court of Common Pleas for a breach of the duty of fair representation.
No.
And by the way, and not name the employer.
No, Your Honor, I'm not saying that at all. They still have to meet the standard of duty of fair representation, which is bad faith. They're going to have to plead that the union acted in bad faith. The union just saying, I'm not going to take your case to arbitration because we think it's frivolous certainly isn't bad faith. But if they send an email to them saying, I'm not going to take your case to arbitration because you're not a member of the union and you're a freeloader and you're sponging off of us, then we have a different case, and that's the case we have here. And one factual distinction, again, that I think needs to be drawn out is we're not talking about an unresolved grievance here. We're talking about one that was settled, one that the employer considered done. So again, it's really not fair to haul that employer, the public employer, back into court years after the fact when they considered everything completed. Again, I think if you draw this to its logical conclusion, we get to a point where unions, if they're never going to be held liable for damages, and if anything involving a grievance, they can just fall back on whatever they want to, and at the end of the day, the only thing that they're going to get from a court is the court has to sit in equity, it can't sit at law, and the only thing that they can get from that court is an order telling them to go back to arbitration. There is absolutely nothing that prevents the union from doing it again. And that, I think, undermines the whole basis of tort law in this Commonwealth. And frankly, Your Honors, it would be out of step with the way that every other state and jurisdiction handles the duty of fair representation. You'd be creating something totally new and really unheard of in the state of law. Again, there are a line of cases in Pennsylvania that deal with situations where the employer may also be implicated in breach of duty of fair representation. And as I pointed out, the courts have recognized that where the employer also engaged in it, it's okay to award damages against them. And there's also cases that clarify that the public employer, though, if they weren't involved in that, should not have to pay damages for the union's wrongdoing. And that's kind of where the apportionment thing comes up. And Martino hints at it. I don't think Martino really hashes out how that would work. That is how it works under the federal system. Of course, one thing being missed in all of this, though, is in the federal system, or in a lot of states, I should say, the duty of fair representation is found in that state's Public Employee Relations Act. Here, the General Assembly, first and foremost, the duty of fair representation in this Commonwealth was developed by this court in 1960. And it came from federal law, and it endorsed it in 1960. PARA comes in 1970. When the General Assembly passed PARA, it did not include the duty of fair representation. It was nowhere to be found in that act. It did not provide any venue for someone to litigate that, and as this court has recognized since, the proper place to do that is in a trial court, in a court of first impression. And that court, sitting in law, has everything at its power to award damages against the union when it's really the union's discriminatory bad faith action that's at dispute.
So you mentioned other jurisdictions. Are you aware of any other jurisdictions that have allowed an employee to seek monetary damages against the union for violating the duty of fair representation?
I have. Actually, we cite one with a recent case out of New Mexico. And I think that case is telling because it's also a state framework where the duty of fair representation is not embedded in that Public Employee Relations Act. It's a creature of common law, just like it is in this Commonwealth. And I'd submit to Your Honor that that's a really compelling case. In that case, Aikens, I believe it is, and we briefed it, there was actually an award of punitive damages that the union then fought against, and they said, no, this is a common law tort, and it doesn't arise under our Public Employee Relations Act, and because of that, we can award damages against the union and punitive damages. And I submit that that should be the state of law in this Commonwealth as well.
All right, thank you. Well argued by both counsel. Thank you so much.
Thank you, Your Honors.
Mr. Minner, will you call the next case?
Betty Bell versus Wilkinsburg School District. Representing Ms. Bell, Mr. Alan Shuckrow. Representing the school district, Mr. Christopher Bolts.
In this discretionary appeal, we must determine whether the Wilkinsburg School District violated Section 1726AA of the Charter School Law by providing charter school students who reside within its boundaries with free bus passes as a means to travel to and from their respective charter schools on public transportation, while providing the students attending its own schools with traditional yellow school bus transportation. I don't know if they're all yellow, but that's how I think of them. Please proceed.
Thank you, Your Honor. Madam Chief Justice and the other honorable justices, I guess in this session, the first shall be last, or the last shall be first or last. But I'm very happy to be here. I'm Alan Shuckrow, representing Betty Bell and Propel Charter Schools, who I've represented since their inception in 2003. With me at council table is my longtime partner, David Strasburger, and my friend, Kevin McKenna, whose firm authored an amicus brief in support of our position. There is no basis in Section 1726A of the Charter School Law to treat public charter school students unequally from their traditional public school district colleagues or neighbors. When it comes to transportation, Section 1726A should be interpreted to require equal transportation because the General Assembly does not intend to favor one class of students over another. Consider a child, or in Ms. Bell's case, a grandchild, age 5, 6, 7, being forced to accept mass transit without supervision as the only way to get to the charter school, while children attending the district get a yellow school bus. Ms. Bell testified that she would be worried sick. I think we all would. And I submit that it would be the end of any consideration of sending a child to a charter school.
Were
which
the
is
children as young as 5, 6, 7 in this
Yes.
situation?
Yes. Yes, it was a wholesale policy by the district to make this change before the 18-19 school year.
But counsel, you'd be okay with that if the traditional public school children were also taking public transportation?
When you say would I be okay with it, Justice Donahue, in terms of interpreting the statute, our argument here today is that the classes of students should not be treated unequally like this.
I understand that, but,
right.
but in your brief and otherwise, you make a big point of the fact that this is a terrible thing to do to kids. It's a choice of the legislature. They allow common carrier. So your position has to be if traditional public school children and charter school children were taking common carrier, we wouldn't be here.
That's correct, Your Honor. I think that
You might not like it.
Yeah.
But we wouldn't be here.
that
But
well,
that's for the legislature. I mean, they
I
allow common carriers.
common carriers are allowed and were allowed when the school code was enacted in 1949. I agree with that. What we're here on today and why the court took the case that Chief Justice Todd articulated is the unequal treatment among similarly situated classes. That is correct. And I think the record is clear, and even Judge O'Brien, who ruled against us on the legal argument. I think everybody's been troubled by this situation as this case has been up. This is the second time it's been here. He made a finding in his decision saying that Wilkinsburg was treating its students better than it was treating the charter school students, and that's a finding that you have here in this case. And I would, sorry.
Unless that violates the law, that's just a gratuitous comment. I mean, the question isn't, is this nice, or is this not nice, or is this good, or is this bad? The question is, does it violate the law? So again, how do you deal with the common carrier language?
Well, the common carrier language is not in Section 1726. Okay, Section 1726 unambiguously provides that the charter students are to be provided free transportation. Okay, that's clear. Okay, and there's also language that was. Let me say it this way. What's been stated throughout this case, and what the Commonwealth Court's majority opinion stated, is that the former version of this section had language that said same terms and conditions. Okay, but then in 2002, that particular little phrase was eliminated, and that because of that, that's how we're getting to this, what we would say is an absurd and potentially unconstitutional result. So what I want to do is, by using the Statutory Construction Act and looking at some of these factors that we believe you should consider, such as the occasion and necessity for the statute and the circumstances under which it was enacted, I want to take us back to December of 2002 for a moment. And at that time, the Mosaica case was pending before this court. And at issue in that case was whether the Philadelphia School District was required to transport the charter school students that lived in Philadelphia for outside of its boundaries for 10 miles. And what 1776 said at the time was it referred to Section 1361 of the school code that, and it was ambiguous really as to whether it was going to be a requirement for Philadelphia to do that transportation outside its boundary or not. And the case was argued before this court, and it was pending. And Governor Ridge, who was a proponent of the charter school law, got it signed into law just 5 years earlier in 1997, and the legislature got together and put an amendment in that makes it clear that basically took care of the main issue in Mosaica, because what was added was that the transportation would be required for the charter school students outside the district boundaries, not exceeding 10 miles. So it made it clear, all right? So the legislature in 2002 was not trying to take something away from charter schools. It was trying to add and help the charter school students at the end of Governor Ridge's administration, I would submit. And when we're looking to interpret this section, we should not be interpreting the maybe mistaken omission of the same terms and conditions language in 2002 as a negative or a huge change in the law. In fact, when the law was amended, the legislature specifically said it was a clarifying amendment, okay? Clarifying amendment. And as my colleague, David Strasburger, who I introduced earlier, wrote in our brief, that Congress does not hide elephants in mouse holes, but by making radical changes through clarifying amendments. And so if this was supposed to...
Somebody wrote that before Attorney Strasburger. I think somebody with the initials AS, like Attorney Strasburger, but in that case, Antonin Scalia.
Gotcha. Thank you, Your Honor. In any event, we're trying to look at the legislative intent here, and I would submit to you that there is no intent in 1726 to treat the charter school students differently or more poorly. I mean, remember, they're public students. They're public school students. The question that the court is asking is very clear in recognizing that. There's no rational basis to look at the public charter school schools students differently than the district students. I want to,
How about the language? Why don't we talk about the language of the statute that we're attempting to interpret? I think that's what we're doing, right? Like the current statute.
correct.
Why wouldn't same conditions refer to the non-hazardous conditions that is referenced maybe 12 words before the word conditions?
Right, okay, so, this, as I actually believe that our opponents stated in their brief, this statute is densely worded, okay? It's very long.
Well, this part isn't.
Well, it had, it was the end of this, of A, talking about the hazardous conditions and the 1.5 miles and 2 miles was added later. It was added, I believe, in 2006. And it talks, what it's basically saying from my reading of it, is that it's carving out an exception for students who live close to, I think what it's supposed to be saying is students who live close to their charter school, even though if you read the language, it talks about living close to a highway, okay, which, it's poor, well.
Measure from a farmhouse that's a half mile away from a highway.
Sure.
I mean, that's a legitimate qualification.
Sure, but the first part is carving out an exception, but then it's bringing back the equal transportation if the school district does the same for its students. It's saying the transportation shall also be provided to the charter schools under the same conditions. And the way I read that is under the same conditions, just like we do with everybody else.
Well, wouldn't it say mode? If you were right, wouldn't it say the same mode of transportation?
Okay, the word mode is not in here, and I want to tell you something that while this case has been pending, similar to the Mosaic case, I've been working on. If we got to this point, it's hard to come up with words to say this, and so I think what we really need to be doing is taking a half step back and read this and interpret this in conjunction with the charter school law and the school code and the real consequences if school districts are permitted to wholesale say, we're going to put the charter school kids on Port Authority or whatever it's SEPTA, whatever, and we're going to protect our own kids. That is the death knell of the charter school law and the charter school movement in this Commonwealth, because we all know that from the very beginning, the school districts have resisted charter schools for a number of reasons, and that continues today. And school districts will continue to do this as holding transportation as a weapon against the charter schools. That is not what this statute means. This statute means the charter school students are supposed to be able to get to school for real.
The command of the statute is shall provide free transportation. Share with me how that's being conflicted with your view. If they're being provided free transportation, we may not like it as parents, but it's following the mandate of the statute. The rest is just giving you an idea of how this free transportation is going to be, employed.
We need this statute is not unambiguous that it says we can treat them differently. It doesn't say that, okay? So what we need to do is we need to look at the intent and we need to look at the statutory construction factors, including.
It's not ambiguous.
Well, we say it is ambiguous, and in fact, the Commonwealth Court, as I stated earlier, in their majority opinion, they say they believe it's unambiguous, but then what they do is they go back to 2002 and they talk about what the former version of the statute was. And so they're going outside the four corners to get there, okay? And what I'm saying is this court, no court in the Commonwealth, in any opinion that I ever saw, says that we can treat a class of students fundamentally different than another class of students. And let me read.
The requirement is free transportation. Are you denying that a trans pass is free transportation? Because I would have to agree with Justice Webb. The word mode is not in the statute, but that is directive as to the same type of free transportation. All that's required by the statute is free transportation. Now, share with us how that is unambiguous or ambiguous.
And are you arguing the dangerousness of it?
Yes, I mean, I'm arguing the outcome of interpreting the statute in this way. That's the outcome.
But then you're arguing against the legislature's policy decision to include public carriers within the context of providing free transportation. That doesn't have anything to do with this. I mean, you don't like the fact, and many people don't, I'm not suggesting, I don't have an opinion one way or another on the legislature's policy choice along those lines, but they decided that public carriers, common carriers, would be free transportation that could be provided to school children. You know, that if that's where your problem is, that's a different challenge.
That's not the problem that's before this court, as we've all agreed, I believe, okay? The problem is the categorization of unequal treatment, and we have raised the doctrine of constitutional avoidance, and I would submit that if this court interprets this statute to mean that what the district did here is lawful, that will be found to be unconstitutional.
Can we get into that for a moment? Because,
Sure.
I mean, it seems to be a make-weight. I mean, it's easy to say that, especially in light of what the majority did in the Herald case. But the truth of the matter is, you did not bring a constitutional lawsuit here.
Yeah.
So if it's unconstitutional, why don't you bring a constitutionality claim? Because here, it's sort of a, like I say, it's a make-weight, or a bootstrapping effort to buttress your, you can't have like a quasi equal protection case. It's either an equal protection case or it's not. So here, I take this as a statutory interpretation case. And so, given that that's the level we're on, the question becomes, what did the legislature do? Not, does it seem unfair to us, like from a seat of the pants perspective, so we're just gonna mandate school buses for charter schools when the legislature didn't say that.
This is not a facial constitutional challenge. I think we had a case earlier today, and I heard the same argument, right? I mean, we're using the doctrine of constitutional avoidance as a statutory interpretation tool in this case. That's where this is coming from. And I would point out that during the course of this last 7-year winding road of this case, the Commonwealth Court did issue a landmark opinion declaring that education is a fundamental right in this Commonwealth. And my point in raising that,
Something to do with that. We decided that case, right? We decided William Penn School District.
I believe you sent it back and asked the Commonwealth Court to hold a hearing, right? Right.
But again, my point is, that was a constitutional case. This is not a constitutional case, and it's sort of, I'm sorry to beat up on this. I'll try to stop after this, but you can't. It seems to me you can't say, justices, this is a statutory interpretation case with a kind of sort of constitutional flavor. So, like, give us sort of an equal protection quasi leg up. You're not on the constitutional level here. You're on the statutory interpretation level. And the question is, does the statute support a compulsion to equalize the mode of transportation? Am I getting that wrong?
I think you're right, and I think that's what we're here talking about. And my purpose in bringing up the constitutional issues is that I believe it's a tool and an aid to the court to determine the intent of the legislature.
I don't blame you in light of what my colleagues did in Herald, so go for it.
Well, let me read something to you. There's a case that the Commonwealth Court cited to. It's called the Chipman case, and the Commonwealth Court cited to it for the proposition that the court is not to look at the pleasantness or quality of an individual's transportation. And in that case, there were some bus transfers. There was a whole, but what the court did, this is the Commonwealth Court from 2004. What the court did say is, although the school code does not address the quality of an individual non-public student's transportation beyond safety, there can be no reasonable dispute that the school code contemplates identical policies for transportation of public and non-public students. Thus, while evaluation of an individual student's arrangements is limited, evaluation of arrangements for transportation of the class is appropriate. And what we're asking this court to do is to evaluate what the school district did here. It's admitted to policy. There are no facts really at issue here of doing one thing for the charter school students. That's, I think, we can call it free transportation all we want, and we can call it common carrier all we want, but we can all see the outcome and what it's going to do, and how this impacts, having little kids transfer on Smithfield Street in downtown Pittsburgh at 6:30 and 7 o'clock in the morning. That there's no way that the legislature ever intended that. And what I'm suggesting and asking that the court does is evaluate this. Look at our brief again, look at the amicus brief, the history behind the charter school law and how the different versions have evolved. It's clear that the legislature has wanted the charter school students to get to school safely so that school choice can be preserved. And I would ask.
I'm sympathetic to that argument. However, in order for us to even get there, you have to demonstrate some ambiguity in the statute. And maybe I missed it when you did that, but.
Well, okay, I mean, we have there's a very long section in our brief on that, okay?
Your argument,
Right. And I mean, look, let's pull it out. I mean, it says, I have it here. It says, students who attend a charter school located in their school district of residence, a regional charter school of which a school district is part of a charter school, and then shall be provided free transportation on the dates and periods that the charter school is in regular session, whether or not transportation is provided on such dates and periods to students attending schools of the district. That's the first sentence, and that seems to be very clear that charter school students are to be transported. And again, it does not say that charter school students are to be treated differently. It doesn't say that, okay?
It says that children should get free transportation.
That's correct.
The question that we again asking you is, tell us how the word free transportation is ambiguous.
Well,
Not in its well, even
Or any of the language. I haven't heard how any of the language.
well, again, the rest of this statute is, I think it's confusing. But again, this language here that was tacked on in 2006, transportation about the hazardous and non-hazardous conditions, transportation shall also be provided to charter schools under the same conditions. I would submit to you that the reason that language is there is because the legislature is saying we want charter school students to be transported under the same conditions, just like the beginning of the statute. And that's what I believe to be the intent.
And I think that's where your ambiguity arises from, because today in the courtroom, we've heard Justice Wecht refer to that sentence as meaning the mode of transportation. You've had Justice Donahue refer that sentence as meaning the same non-hazardous conditions as occurring in the preceding paragraph. And I myself happen to believe that it means that the charter school students should be on the same school buses as the public school students.
Well, and I also would refer you to Judge Wallace's dissenting opinion, where she indicates that she believes that the intent was to provide charter school students with the same transportation options as their peers attending traditional public schools, and that was the intent of the legislature in adopting this section from the very beginning of time.
All right.
Thank you.
We understand your argument. Are there any other questions? Okay.
Thank
you
you.
very much.
Appreciate it.
Let us hear from Mr. Volz.
Good afternoon, members of the court. May it please the court, my name is
Hold the microphone up, Mr. Volz. Thank you.
Absolutely. My name is Christopher Volz, here on behalf of the Apelt Wilkinsburg School District. To my right is my colleague and the district solicitor, Matthew Hoffman. May it please the court, respectfully, it appears that Propel Schools wants this court to rewrite 1726A to put in a requirement that is not there. In our position, Section 1726A of the Charter School Law unambiguously imposes a mandate on public schools to provide free transportation by school bus or city bus for certain charter school students and nothing more. The statute plainly does not require that charter school students receive identical transportation as to their public school counterparts. Moreover, Pennsylvania's school transportation laws have always treated students differently based on the schools they attend, without violating the Constitution or raising any grave constitutional concerns. As noted by the Commonwealth Court and this court, Propel Schools never raised any constitutional challenge to 1726A of the Charter's law. Instead, they have tried to disguise a constitutional claim under the guise of statutory interpretation. But, this fails for several reasons, but most notably, in order to get the statutory interpretation, the statute needs to be ambiguous. And I respectfully posit that this statute is not.
How can it not be ambiguous when you have three definitions of that phrase right here, right now, coming from this bench live?
Well, just because learned people come to different conclusions, I believe I can convince the members of this court that it is clear.
Absolutely the definition of an ambiguity when you have a clause in a statute that two or three different, I hope we're reasonable people, could read to mean a different thing.
I appreciate your point, Justice Mundy. Respectfully, though, the first sentence lays it out clearly. Charter school students shall be provided with free transportation. Free transportation is a defined term in the school code, and it includes school buses, common carriers, electric railways, and private transportation. When the legislature defines something, that definition is binding. And I think it's important to note that, this sentence actually gives charter school students more transportation rights than their public school counterparts. School districts aren't required.
It doesn't matter very much if they aren't safe transportation rights.
No, but I mean,
That's
schools.
beside the point here. I understand.
No, but school districts issue charter pass schools. I know Pittsburgh Public does to some of its students. It's not uncommon for that to happen. But what they don't need to do is give all of their students access to transportation. It's optional. Unless you're a charter school student, then you're entitled to free transportation. So if we're going to get into an unequal treatment argument, I think that has been fairly consistent. I think it's also important to note that the legislature removed the requirement that charter school students receive identical treatment. And when initially enacted, the language stated that students who reside in a school district in which a charter school is located, shall be provide transportation to the charter school on the same terms and conditions as the transportation is provided to students attending the schools of the district. Non-resident students shall be provided transportation under 1361. Now, 1361 applies to all school students, and it basically says that school districts may provide transportation to their students to the schools that are located within the district boundaries or within 10 miles of the district boundaries. And then it has a second requirement that if it does so, it needs to make identical provision of transportation to people attending non-public, non-profit, private schools. In 2002, that language was deleted. It incorporated from 1361 the 10-mile requirement, but it replaced the language of identical transportation with free transportation, which has long been in the school code and was well known to the legislature when it made this change. Now, the issue of potential ambiguity comes in the second sentence, which I posit was not added until years later in 2006. So when terms and conditions was deleted in 2002, it was not there from 2002 to 2004, and when it was added in later in 2006, it couldn't possibly have referred under this doctrine of statutory interpretation to what it originally meant. Because you don't go back to the original statute with amendments, you go to the one that existed when the amendment occurred. And when it was enacted in 2006, conditions clearly relates to traffic conditions and road conditions. It does not relate to the mode of transportation. So based on that, I think it is, to the extent it is not clear on its face, the legislative history and the doctrine of statutory interpretation confirms that when the legislature enacted the amendment in 2006, the term same conditions has nothing to do with the mode of transportation.
Nothing to do with safety?
Safety is covered by 1362. The legislature gives us specific details about what constitutes safe. They can't walk more than 1.5 miles, there needs to be shelters, and there can't be any hazardous walking routes. In this case, the court found that all of those factors were satisfied with the Wilkinsburg program.
Okay.
Thank you for your time. It's always been a pleasure.
All right, any questions? Okay.